regarding jury instructions in the proposed verdict form. I think we're very, very close on having those finalized, and I appreciate their input on the court's proposed instructions. You will have an opportunity to make any formal objections that you wish to make on the record. My staff attorney will revise those documents and email them to you, Ms. Jensen, or
that would be great, Your Honor.
Or more than you.
He could send to everybody on the caption if he wants, and if he doesn't, I'll just forward it on. So.
Okay. Are there any other matters that the plaintiffs wish to bring up this morning? Mr. Stidham, I just made a record that we had an informal conference on the instructions and verdict form. I also want to make a record on having reviewed the binder that you provided about documents that you seek to admit, and I'll take that up when you seek, when you offer them. I'll make my ruling on those documents.
Thank you, Your Honor.
And is the witness present?
He's on his way in, Your Honor.
Okay. Please call the jury. Do you have a statement? Very good. Please be seated. Good morning, ladies and gentlemen. Did anything happen over the recess to affect your qualifications? Seeing none. Mr. Clerk, will you please re-swear the witness?
Do you solemnly swear or affirm to testify about the defense matter now before the court should the truth, the whole truth? I do. Thank you.
Mr. Fomby, if we could just go back to where we were when we took a break last evening. Could you go to page 25 of Mr. Fomby's demonstrative, if you could, Mr. Bollinger? Mr. Fomby, this was the portion of your demonstrative that we ended on last time. Is there anything regarding demonstrative page 25 that you'd like to address with the jury in support of your opinion?
Well, as it applies to this, I mean, the main thing to consider is the nature of the ongoing threats. As I discussed before, there was a media figure that posted information about events that happened a year prior. And 1 year later, so this is May of the following year, you have an immediate spike with people contacting St. Luke's Hospital on May 2nd, not understanding that this event had happened a year prior and threatening the call takers there. So it really speaks to the pervasive nature of this information once it's online, and anytime somebody sees it, they may act on that information.
And Mr. Fomby, is an aspect of this opinion number 5, the number of individuals that get swept up in the targeting?
Yeah, so there really is no way to limit the number of people that that this affects. So as we discussed before, we have the plaintiffs being affected directly, but it also affects everybody related to St. Luke's, all of the employees and people that may potentially have any association with St. Luke's.
If we could move on to page 26 of Mr. Fomby's demonstrative. And Mr. Fomby, here you've identified individuals targeted by defendants. Can you explain the significance of this as it relates to your opinion?
Yes, this is a list, and it's not a complete list of all the people who have been targeted for harassment, intimidation, and doxing. So if you consider everybody who had some part in this case, most of them just doing the job that they were sworn to do, and they became targets of this type of harassment. And the thing I really want you to focus on is some of these people are law enforcement officials, including some of the top law enforcement officials in the Treasure Valley, and judges.
And just so we're clear, these are individuals you've identified who were targeted in relation to this false St. Luke's conspiracy?
Yes.
And you'd indicated that the significance were some of these individuals were law enforcement and judges. Can you explain to the jury why you believe that's of significance?
Well, we know that Bundy and his followers typically target law enforcement officials, but some of this behavior was directly intimidating, really trying to focus on them in their personal lives, targeting them at home, and making really wild accusations about their involvement in this conspiracy.
And does that factor into your assessment of the level of risk?
Yes.
How?
Well, anytime you're targeting somebody in their personal life and not addressing their professional duties, that creates more risk. And especially if you're going to go to the level where you start targeting police officers at their homes, that just shows how far people are willing to go to promote their ideology.
Could we move on, Mr. Bollinger, to opinion 6 for Mr. Fomby? Mr. Fomby, would you read this opinion to the jury?
So it is my opinion that there is a need for accountability to deter this behavior.
And what does that mean in this context, Mr. Fomby?
Essentially, there hasn't been any consequences for this behavior, and this strategy, this tactic has been going on and been used for a long time. But as it applies to this event, the medical attention that this infant needed, they have really ramped it up and taken it to a different level. So it is my opinion that if there are no consequences for this behavior, this will continue.
And Mr. Fomby, just so I'm clear, is this opinion specific as to the defendants in this case?
No, it relates to their overall strategy and their ideology, the tactics that they use. They are applying it in this case for this specific purpose and targeting people involved in this particular event. But they apply that strategy over and over to anybody that they identify as opponents. And once they target them, they use the same tactics.
And I guess maybe I can ask that last question a little bit better. Is your opinion regarding the need for accountability, is that accountability for the defendants in this case?
Yes.
If we go on to the next page of Mr. Fomby's demonstrative. Thank you. Mr. Fomby, could you explain what the NATO pyramid model is and its relevance here?
Yes, I understand that you have seen this before. This is a model that was created by the experts at NATO to help people understand the process of radicalization for anybody who receives certain information and their potential and likelihood to become a violent extremist. The way the model works, for anybody who is curious about a certain ideology or a certain organization, they would fit into what is violent, extreme, curious. That is all of those people. Out of those people, 10 to 30% of them may move into a category considered violent, extreme fans. out of that group of people, about 10 to 30% of them will then move on and continue along the spectrum into what are considered extremists. And that out of that group, 10 to 30% may commit acts of violence that will move them into the category of violent extremists.
Thank you. If we could move on to the next page, Mr. Bollinger. Can you explain what you mean there, Mr. Bundy, to the jury with that expand scope note?
So what this means is if, extremist groups want to expand their scope and expand the number of people that are exposed to their ideology, their rhetoric, and their propaganda. So one way to do that is to continue to add layers to a conspiracy. So as you've heard before, if you have this idea that the infant was torn from its mother's arms, and then you add a layer that police officers and social workers and doctors and nurses and judges and everybody are involved in a wider conspiracy. They believe that it tends to keep attention on this issue and then also bring more people into the fold.
And just so I'm clear, is that what you're referring to with regard to your note, ongoing false conspiracy?
Yes.
And you've also got a note there regarding speed of radicalization. Can you explain what that means in the context of the pyramid model?
Yes. So extremists know that they can speed the process of radicalization of an individual by increasing the content that that person absorbs. So the amount of content that they see, things that they hear, all of that messaging, the more content that person takes in, the faster that they potentially become radicalized.
And I think your last bullet point there is expand platforms. Can you explain what that means in the context of speed radicalization?
Yes, another way to increase the speed of radicalization is to have that person absorb information through the use of various platforms. So it's not just that they're receiving it from one social media outlet, they're receiving it from various social media outlets, emails, text messages, any type of medium that they can use.
Thank you, Mr. Fomby. And did you do some analysis to apply these concepts to the situation here with PRN and Mr. Bundy?
Yes.
What did you do in that regard?
I looked at the available evidence and then also took a look at some particular examples of people involved in PRN and their roles and their process along the spectrum of being radicalized.
Thank you. Mr. Bollinger, could we go on to page 30? And can you explain any modification you've made here and its relevance to your analysis?
Sure. So if we apply the NATO pyramid to PRN, we just replace violent extremists with PRN members or people who are interested in PRN. So a person who may have some interest in the ideology and the philosophy or in the messaging or in Ammon Bundy himself would be PRN curious. When that person increases their interest and interaction with the group, then they move into the category of PRN fans. As they continue along the spectrum and get more involved and their the rhetoric and activity increases, then they move into PRN extremists. And then those who are willing to take up arms and use violence in support of the ideology move into PRN violent extremists.
So so we can get a framework here, where would someone be who's just attracted to the PRN website and is reviewing the website?
PRN curious.
And if we could move to page 31, Mr. Bollinger, of Mr. Fomby's opinion. Mr. Fomby, have you reviewed what has been identified as redacted Exhibit 258R?
Yes.
And is that relevant to your opinion?
Yes, it is.
Is that an email sent by a PRN member?
Yes.
And Your Honor, I'll represent that the redaction is just to remove irrelevant and potentially more personal information from the exhibit. And, Your Honor, this was authenticated by Second McCraney at paragraph 12.
.258 is admitted and may be published.
And to be clear, Your Honor, that should be 258R for the redaction.
Thank you.
Mr. Bullinger, could you expand just that first paragraph? Mr. Fomby, would you read that for the jury?
I curiously began following the Bundy Ranch fiasco. I researched the tortoise explanation, the not paying lease fees, the other possible reasons that the FBI had painted to justify their actions. My quest to understand took me to Senator Harry Reid's probable action to sell that land and its minerals. That seemed the most accurate. The Smithsonian Magazine said that the tortoises were overpopulated in Nevada. Cliven Bundy is still paying range fees and grazing cattle there. That was an unbelievable ordeal, and the only violence I witnessed was from the FBI. I watched the videos replay many times.
And Mr. Fomby, do you have an understanding of the facts relating to that standoff? And are the facts, isn't it true that the facts she's relating are false?
That's correct. That is not how the sequence of events happened. This is not factually accurate.
So can you explain the fact that this is an individual who's accepting incorrect facts? How does that factor into where they are on the pyramid?
Well, if you look at, she actually uses the word curiously. So if you look at the pyramid, she's starting off with some level of curiosity and interest in Ammon Bundy and in the organization, but quickly starts to move through the spectrum.
Thank you. And Mr. Bullinger, could you pull out and expand the next section of text so Mr. Fomby could read that? Mr. Fomby, would you read that to the jury?
I will share with you a personal experience I have had when I first met Mr. Bundy and shook his hand. I was moved to tears and had to look away. This man is the closest to a Jesus Christ in his heart that I have ever met. The thought of him being attacked and persecuted the way you are paid to do is heartbreaking. Mr. Bundy stands firm. He pays a price for that, and in no way, shape, or form is he violent. If you have children and you had one as righteous as this man, you would be one lucky dad. So much is being exposed regarding CPS here in the U.S. After this is over, you might regret not standing on a different side of the fence.
So could you unpack for the jury what you see as relevant in this section?
Sure. I think the thing that stands out most is, anytime you see a person look to another person, especially in a leadership position like this, and identify them as Jesus-like or as Jesus, that is always a sign that this person is now moving pretty aggressively through the spectrum. So this is clearly a person that has moved into at least the fan category as a PRN fan.
And I think if we go back to one of your earlier comments, I think it related to the organization moving people through the through the radicalization process. Is that correct, Mr. Fomby?
Yes.
And is there anything here that would indicate to you that the organization or Mr. Bundy are taking steps to move this individual through the radicalization process?
Well, I think for most organizations and most people who are following an organization or following a person, they actually don't have a chance to have direct interaction with that person. They may see them from afar. They may receive that message through social media or watching videos and start to build that connection. But anytime you have a one-on-one connection and you're able to meet a person and interact with them directly, it has a more profound effect typically, and that's what you see here.
And Mr. Fomby, have you done any review of PRN literature regarding whether it is works to create a mythology around Mr. Bundy?
Yes, just like any other extremist organization that uses a spokesperson or puts forth a person who is the figurehead, you want to create an image around that person and have people gravitate toward that person and their image.
Where would you place this individual on what you've identified as the NATO pyramid?
Without knowing any specific actions that this person took as a result of meeting Mr. Bundy, and what she's expressing is her feelings toward him, or the adoration that she has, I would say that she's a PRN fan.
Thank you. And I should have asked this at the outset, Mr. Fomby, but does the risk posed by a target increase as it relates to that individual as they move through the funnel?
Yes, the purpose of this evaluation of radicalization using this type of model is to see and identify the number of people and the type of person that potentially will become a violent extremist. In this case, again, the majority of people are just curious, and some of them become fans, and a much smaller number actually take violent action.
So if we can move on to, excuse me, Jeff. If we could move on to the next page in your demonstrative. Can you explain what's set forth here, Mr. Fomby?
So this is another example as we look at another individual involved in the PRN movement. We could treat this as a kind of case study looking at a pattern of behavior.
And who's the individual that you've identified in this example?
His name is Robert Jones.
And is he a member of PRN?
Yes.
Okay. And, excuse me, Mr. Fomby, have you reviewed what is Exhibit 135?
Yes,
And does that relate to and support your opinion?
it does.
Your Honor, we'd ask to move for the admittance of Exhibit 135. It was authenticated in paragraph 19 of the June 28th McCraney Declaration.
Exhibit 135 is admitted and may be published.
Mr. Bullinger, would you highlight the section that there where it says 2 men arrested down to the 2 paragraphs of text below? And Mr. Fomby, can you identify which of those individuals is Mr. Jones?
It's the man on the right.
And would you explain the relevance of this in your analysis?
Sure. So there was an event where members of PRN were protesting COVID mandates, and a group of people went to a county commissioner's house basically to intimidate and harass her. They were there banging pots, honking, or using air horns. Some of them were obviously armed with firearms, and the county commissioner that they were targeting was not home. They ended up terrorizing 2 of her children and her mother. They were eventually arrested and charged with disturbing the peace, and Mr. Jones was sentenced to 6 months in jail.
And then if we could, Mr. Bullinger, just so we can let Mr. Fomby capture any portion of the text he would like, could you get that last 2 paragraphs under the picture below, Mr. Bullinger? And could you read that paragraph there that begins Jones?
Jones was arrested near a pop-up tent next to a small group of people at around 10:39 a.m. Pettinger was arrested as he and a small group of people entered the Capitol building at around 11:47 a.m. Both men were booked into the Ada County Jail on charges of disturbing the peace from the December 8th incident.
And to your understanding, are both of those men PRN members?
Yes.
If we could go on, Mr. Fomby, if we could pull back Mr. Bullinger to page 32 of Mr. Fomby's demonstrative. There's a second, excuse me, Mr. Fomby, there's a second bullet point there Could you explain the relevance to the jury?
So as a result of the criminal charges against Mr. Jones and his conviction and sentence of 6 months in jail, Bundy made public statements calling the judge a wicked person and praising Jones for his actions.
Do you have any opinion regarding what effect that has on a person who's in the process of radicalization if the cult figure or the leader takes a special interest in an involvement like this?
Sure, it's just like it is human nature to look for that type of approval, and where a person is taking certain actions in support of an organization or in support of a certain person, and then that person recognizes them, and especially recognizes them publicly, that is likely to lead to further radicalization.
And Mr. Fomby, I'd like to go to what has previously been identified and admitted, as a threat assessment report. Mr. Bullinger, that would be Exhibit 42, page 5. Could you highlight the upper right-hand corner picture? And can you explain what the jury's seeing there?
So this is a picture from a threat assessment that has previously been presented, a threat assessment created by the St. Luke security team. And this is a photograph of Mr. Jones outside of the hospital carrying a firearm.
And this, and just so we've got the timing right, this is March 12th of the disturbances at St. Luke's in Boise, is that correct?
Yes.
Okay. What is the significance as it relates to any threat assessment relating to St. Luke's that this individual who you've been providing us some background on is now showing up at St. Luke's armed on what is in effect the first day of protests downtown?
So if we look at First Amendment free speech and protest activity, we all have the right to do that. So there's no problem that he's showing up to protest. The concerning part is his previous behavior, and now he's showing up to the protest armed with a firearm. So the issue here is in Idaho, people are allowed to carry firearms concealed. So this isn't necessarily an issue of self-defense or the fact that he's allowed to carry a firearm. It's that he's carrying it openly in a holster, which is meant to intimidate people. And
Mr. Fomby, let's go back to page 32 of your demonstrative, if we could. You have another bullet point as it relates to your analysis regarding Mr. Jones, and that's Jones speaks at the PACT rally. You see that?
Yes. So the next series of events where we identified Jones moving through the spectrum is him speaking at a People Against Child Trafficking rally in March 2022. That was on the Bundy property.
And the jury's seen a video from this. You reviewed that video, haven't you?
Yes.
And that the video in which Mr. Jones is appearing as a speaker, that's the same rally that specifically targeted Dr. Natasha Erickson, correct?
Yes.
And did Mr. Jones at that rally speak out against Dr. Erickson and St. Luke's?
Yes.
Can we move on to that last bullet point, if we could? And perhaps you could provide some context for the jury on this one. Can you, first, would you read what that bullet point is?
So is Jones now defending Bundy property?
Can you provide the context for what you've described as Jones now defending Bundy property?
So there was a protective order in effect in the case, and multiple attempts to serve Bundy with summons, and he was actively avoiding receiving those summons and participating in the court process. At one point, he put out a message to his followers and supporters saying that he needed people to rally and to come to his property. Again, making it an urgent plea that seemed to suggest that somehow law enforcement agents were going to surround his property and that there was some potential threat. That led to members of PRN and other supporters coming to the property.
And to be clear, when you're talking about legal process, that's legal process relating to this very lawsuit we're in today, correct?
Yes.
What is the significance, you provide some background, what is the significance to your analysis of an individual who would come to Mr. Bundy's aid, understanding that that might involve an armed conflict with law enforcement?
It just shows the level of commitment for any person to put themselves in a position where they may potentially be carrying a weapon, facing off with police officers, sheriff's deputies, or whatever, or any law enforcement agents that would show up, and then potentially engage in an armed conflict, including a shootout with law enforcement personnel.
And you've prepared a video clip in conjunction with this, is that correct?
Yes.
And have you reviewed what has been marked as, pre-marked as Exhibit 238A?
I have.
And what does that reflect?
It is a video of Mr. Jones, seems to be videotaping himself probably from his cell phone, and narrating his role and responsibilities on the Bundy property.
And Your Honor, this would be a clip, 0 to 38 seconds, and it was authenticated in the second McCraney affidavit at paragraph 30.
Is there foundation as to the date?
There is, Your Honor. It is from the April and May, the April time period of 2023. I don't have the date exactly, Your Honor.
Exhibit 238A is admitted. It is a video clip.
Your Honor, I apologize. It is from June 20. No, I'm correct. It's from the May time period. I'm sorry, Your Honor.
May 23.
23. Yeah.
Okay, thank you.
Would you play that clip, Mr. Bollinger?
All right, folks, this is Robert Jones. I'm out here at Ammon Bundy's place. I figured that I'm going to try to put out an update once a day, just kind of say what's going on here. And, it's not exciting all the time, but here, hold on, I do have some duties to do, so hold on just a second. Okay, just kind of explain my duties a little bit, why I have to pause the video sometimes. I'm the gatekeeper. It's my truck, that's the gate to come on Ammon's property. Just going to try to keep it short, give you little updates every day.
So, Mr. Fomby, could you perhaps explain was there any significance to some of the symbols that we saw on that truck?
Well, you see the upside down American flag is the one that stands out the most, whether it's anarchist or other anti-government organizations. That is one of the ways that they show their political ideology or their philosophy is turn the American flag upside down.
And what's the significance of any of Mr. Jones referring to what he's doing as a duty?
Well, you see that he's clearly in a position, his role in that case is he's using his vehicle to block the road that accesses Bundy's property. He is acknowledging that he is the gatekeeper, so he is the point person standing at that location looking for people who are coming onto the property. You see a vehicle that turns from the roadway and starts to drive toward the property, and that's when he identifies that vehicle and stops the first video to go make contact with that driver.
And could you tell from the video that you watched, was he armed?
I can't tell from the video.
And Mr. Fomby, anything else of relevance relating to that clip that you want to share with the jury in your analysis, relating to your analysis?
I just think it's important to point out, based on all the rhetoric and the intelligence and the evidence in this case, and the history of this organization, we know that the call to action was to bring guns, to have people come there and be prepared for an armed conflict. And now you have a person who has engaged in a series of activities, culminating, at least in this case study, in taking a position, ostensibly armed and ready to engage in some type of armed conflict with anybody who might come onto that property.
And specifically in this case, isn't it true that the anticipated conflict was with law enforcement?
That's correct.
Mr. Fomby, and you've been doing this analysis in the context of that NATO pyramid. Could you apply your analysis of Mr. Jones to that tool?
Sure. It appears that at some point he was curious. He obviously became a fan and quickly moved to activity that would have placed him as a PRN extremist. And at the point that he's willing to, carry a firearm and take action in support of the cause, he starts to move into that area of violent extremist.
And just so we've got the time frame right, this is also after he's done 6 months in jail for PRN, correct?
That's correct.
Mr. Fomby, I know you've done some analysis for us, but is it fair to say you have pretty incomplete information as it relates to internal communications at PRN?
That's correct.
Do you have any concerns regarding what may be getting communicated on these channels that you and others analyzing it don't have access to?
Sure. PRN, just like any other extremist organization, has a public face. So there is information that they purposely put out for public consumption, whether that is for people who they want to intimidate or people that they want to recruit. But there's a whole series of communications that are not known to the public or to law enforcement, and based on the activities they do in public and the things that are public facing, it is concerning, if we think about what might be happening behind the scenes.
And I understand this is just a case study, but maybe to put a bit finer point on it, is this a case study regarding the kind of individuals that potentially pose a risk to Dr. Erickson, Tracy Youngman, and others?
Yes, and this is just one person. If we look at the effect of all of the propaganda, the social media campaign, the doxing, how many people it's reached, how many people have joined PRN as a result, we have no real understanding of how many people have gotten to this point where they're willing to take some type of violent action in support of the cause.
Thank you. Could we move on to page 33, Mr. Bullinger, of Mr. Fomby's demonstrative? Would you read this portion of your demonstrative to the jury?
Bundy has had no meaningful consequences.
And do you provide some examples of what you believe support that?
Yes.
Could you read the first example to the jury and provide some context so they can assist in their understanding?
So Bunkerville and Maher armed standoffs, that refers to two standoffs that Bundy and his supporters have been involved in with law enforcement agents. These are very violent standoffs with a huge potential for a large shootout to break out. In at least one of these cases, a shootout did happen and people lost their lives.
And the second bullet point, could you read that and explain to the jury why you've noted that?
It's trespass cases. So since Bundy's moved to Idaho, he's been involved in a series of events, aggressive actions toward government officials and law enforcement. And those actions have led to multiple arrests for trespassing.
And the last point?
Defiance of court sanctions. So Bundy systematically defies any type of court sanctions. At the same time, he promotes the idea of God-given rights and individual rights. He refuses to participate in systems that apply to everybody in a civil society.
If we go on to the next page of Mr. Fomby's demonstrative, Mr. Bullinger. Could you read that first bullet point and provide some explanation to the jury as its significance?
So in this lawsuit, Bundy has defied court orders and refused to pay sanctions. So again, the same pattern of behavior applies to this particular case where Bundy is ignoring court orders, refusing to accept summons or service from police officers or private process servers, and refusing to pay sanctions.
Okay. And did you cover your second bullet point there? Or do you have more to add to that?
No, that goes along with the same pattern of behavior that Bundy is defying the legal process.
And the third bullet point, can you explain what you've identified there as something that you want to highlight for the jury?
Sure. This is an example of the aggression that Bundy shows in an attempt to avoid being served court papers. So in this case, there are sheriff's deputies who are attempting to serve Bundy with paperwork, and they end up on his property, and this video shows his reaction to that and his attempt to intimidate them.
And just to be clear, that's paperwork relating to this lawsuit, correct?
Yes.
Okay. And, Your Honor, we would ask that this be identified as Exhibit 206A. It's a clip of from 0 to 1 minute 25 seconds, and it was authenticated by the first McCraney at paragraph 30, and that, Your Honor, was from the May 2023 timeframe.
Exhibit 206A is a clip, not the entire video, and it is admitted and may be published.
You guys are a bunch of pricks coming in here. You know what's going on now?
I don't indulge myself in your own paperwork.
Then you ought to figure out what's going on.
It's not my business. You have to go to your day, okay?
Man, what you're doing.
All right, you have to go to your day, all right?
Come back.
And, Mr. Fomby, I should have indicated this is from body cam footage of the Gem County Sheriff's Office, correct?
Yes.
Why was it that you wanted to show this to the jury in the context of your explaining your opinion?
It just goes to show the level of aggression and Bundy's contempt for the process and for law enforcement. These deputies are performing their duties. It is a vital function and role in civil society and for the court to function. And Bundy thinks that these rules don't apply to him, and he's willing to approach the deputies with that level of aggression.
Thank you. If we could go on to the next page of Mr. Fomby's demonstrative. Could you read the first bullet point there, Mr. Fomby?
The defendants are conflict entrepreneurs.
And that term's been referenced in this case before, but could you explain how you're using it here?
So if we consider that, again, in a civil society, there are ways that we seek remedies for issues. If you have a problem with a police officer, you can file a complaint. You can talk to their supervisor. You can go to internal affairs. You can potentially file a lawsuit. Even if you have an issue with a private business, there are ways to address that that we all accept. Here, PRN and especially Bundy, they only use conflict. So they don't try to use the process. They have access to resources where they could hire lawyers, they could file complaints, they could use the normal process to find some type of remedy to this issue. But they focus on conflict, and they use the conflict to raise money.
And this is in the context of your opinion relating to a need for deterrence, correct?
Correct.
So if we go on to the next bullet point, could you indicate to the jury, first, could you read that to the jury?
Impact to business model should deter.
So what do you mean there?
So because they use conflict to raise money and to gain followers, and there hasn't been any real criminal sanctions or criminal exposure for this behavior, really have to impact their business model and take away the incentive to continue this conflict, harassment, intimidation of innocent people just doing their jobs. And the way you do that is to impact their ability to raise money by attacking people.
And could you also move on to that next bullet point and read that for the jury?
Likely continued harassment and incitement if no consequences for the defendants.
Can you explain what you mean there?
We know that they believe that this strategy works. They've bragged about it in writing and on videos. They say that this works, and they will continue to do it. And so we know that, and we have seen that this has continued even through this court process, where they continue to target people involved in the court proceedings. So it is very likely, really guaranteed, that they will continue this harassment and pattern of behavior if there is no deterrence.
I have no further questions, Mr. Fabi.
May this witness be excused?
He may, Your Honor.
Thank you, sir. You are excused. Plaintiffs may call their next witness.
Your Honor, we would call to the stand Mr. Zach McCraney for the purpose of authenticating and submitting some documents.
Please come forward.
Do you solemnly swear or affirm that the testimony about the case matter will be for the court should be the truth, the whole truth? Yes.
That's good. Thanks.
Good morning, sir. Please state your full name and spell your last name for the record.
Zachary McCraney, MCCRANEY.
Thank you. Counsel, you may inquire.
Mr. McCraney, what is your current position?
I'm an attorney.
And where do you work?
Holland and Hart.
And how long have you worked at Holland and Hart?
It's coming up on 2 years. Thank you.
And just so there's no confusion with the jury, we actually work together, correct?
We do, yes.
And you understand you're here solely for the purpose to help us get some documents authenticated and into the record, correct?
Correct.
So, Mr. Craney, do you have knowledge of the facts and procedural history in this case?
Yes.
And how do you have that knowledge?
I've been a member of the case team assigned to this case since it was filed.
And as part of the case team, did you become familiar with the filings in this lawsuit?
Yes.
Did Holland and Hart request and obtain a broker price opinion on the property, relating to the property Mr. Bundy resides at?
Yes.
And have you reviewed that broker opinion?
I have.
Your Honor, I would move to admit, and is that Exhibit 392?
Yes, it is.
And, Your Honor, in addition, this has been authenticated by the second McCraney Declaration, paragraph 7, which also references the affidavit by the broker, Mr. Johnson, and that was filed on July 6, 2023. So we'd ask for it to be admitted, Your Honor.
Exhibit 392 is admitted and may be published.
Mr. Bullinger, could you please publish Exhibit 392 and go to page 2? Mr. McCraney, would you please read the bolded couple of lines in the first paragraph on this page?
We believe that if the subject property had been exposed to the open market in late 2022, it would have likely sold for a price in the range of $1 to $1.1 million.
Mr. Bullinger, could you go to page 3 of Exhibit 392? And Mr. McCraney, is this a photo of the property, is this a photo of the property that Mr. Holland Hart obtained as part of the broker's opinion?
Yes, it is.
And based on the broker's opinion, how many acres is that property?
It's just over 5 acres.
Thank you. We can take down that, Mr. Bullinger. Mr. McCraney, did the case team at Holland & Hart also pull public filings relating to Mr. Bundy's campaign finances?
Yes, we did.
And did you review those filings?
I have.
Was there anything of significance in them?
Yes, the filings showed transactions between the Bundy campaign and then entities owned by Mr. Bundy and Mr. Rodriguez.
And were there some transactions with Mr. Rodriguez directly?
I believe there were.
Okay. And would you take a look at Exhibit 228?
Okay.
And would you identify that for the record?
This is a campaign finance disclosure report. It's a summary page. I believe this is for the 2021.
And would you also take a look at Exhibit 229?
Okay.
Could you identify Exhibit 229 for the record?
This is the 2022 campaign financial disclosure report for the Bundy campaign.
And were both of these authenticated in a prior filing pursuant to the first McCraney declaration at paragraph 40?
Yes.
Okay. Your Honor, we would ask to admit Exhibit 228 and 229.
Exhibit 228 and 229 are admitted.
And Mr. Bullinger, would you publish Exhibit 229 and go to page 327? And would you go to the entry shown here for July 18th, 2022? Could you read for the record that entry of July 18th, Mr. McCraney?
Yes. Power Marketing Consultants, 1876 East Adelaide, Meridian, Idaho, 83642. And then the dollar amount is $3,676.25.
Thank you. And I believe it's previously been established that Mr. Rodriguez, Diego Rodriguez, owns Power Marketing Consultants?
That is correct.
Mr. Bullinger, could you go to page 398, the line for December 28th, 2021? Could you read that first entry for the record, Mr. McCraney?
Yeah, it's partially cut off, but it says Power Marketing, same address I read before, $5,000.
And the entry below?
That is Freedom Tabernacle. The dollar amount is $5,000.
And is Freedom Tabernacle owned by Mr. Rodriguez?
Yes, it is.
Mr. Bullinger, would you go to page 497 the line March 1st, 2022. The entry relating to Abish Hasbandi. So where we're going is page 497 and a line for March 1st, 2022.
And what exhibit are you on, counsel?
I believe that we're still on exhibit 229, Your Honor.
My exhibit only goes to 478.
$457. $457, March 1st, 2022. Could you read that entry, Mr. McCraney, for Abish Hasbandi?
Yes, Abish Hasbandi gives the address and then $1,500.
Okay. And are there other payments reflected to Abish Hasbandi in these disclosures?
There are, yes.
And Mr. McCraney, have you reviewed the Wyoming Secretary of State filing information relating to Abish Hasbandi?
I have.
And would you take a look at Exhibit 591, Mr. McCraney?
Yes, I'm there.
And could you identify what Exhibit 591 is?
It is the Wyoming Secretary of State filing information document for Abish Hasbandi.
And what does it relate, what does it indicate relating to Mr. Bundy?
It indicates on page 2 that Mr. Bundy is the president and director of Abish Hasbandi.
Your Honor, this has also been authenticated by First McCraney Declaration of paragraph 40, and we would ask to that Exhibit 591 be admitted to evidence.
591 is admitted.
And Mr. McCraney, in your review of the campaign disclosures, were regular payments being made by the campaign to Abish Hasbandi?
Yes, they were.
Your Honor, we have no further questions.
Thank you, sir. You may step down. Plaintiffs may call their next witness.
Plaintiff's call Dennis Reinstein.
Do you solemnly swear or affirm that the testimony you give tonight will be the truth, the whole truth? Thank you.
Good morning, sir.
Good morning.
Could you please state your name and spell your last name for the record?
Name is Dennis Reinstein. It's R-E-I-N-S-T-E-I-N.
Very good. I am going to have you sit a little bit closer so the mic can pick you up a little bit louder. All right?
Okay.
Counsel, you may inquire.
Thank you, Your Honor. Good morning, Mr. Reinstein.
Good morning.
Do you work in Boise?
Yes, I do.
And would you describe your educational background?
I have Bachelor of Science degrees in agriculture and accounting, both of which I obtained from the University of Idaho. Then after beginning my work as a CPA, Certified Public Accountant, I attended some non-degree seeking postgraduate classes at the University of Texas in Austin over a period of 3 years. And then annually I participate in anywhere from 1 to 3 weeks of continuing professional education to advance my knowledge and skills in technical areas of my practice.
Thank you. What professional societies do you belong to, if any?
I'm a member of the Idaho Society of Certified Public Accountants, the American Institute of Certified Public Accountants, and the American Society of Appraisers.
And what certifications or professional designations do you hold?
I'm licensed by the state of Idaho as a certified public accountant, and I hold the Accredited Business Valuation designation from the American Institute of Certified Public Accountants, and also the Accredited Senior Appraiser designation in Business Valuation from the American Society of Appraisers.
Mr. Reinstein, would you give us an overview of your employment history?
I've worked as a certified public accountant over the entire course of my career. Initially, I took a job in Lewiston with a regional CPA firm, and over the 26 years that I was with that firm, I became a partner, and I also managed 2 of the firm's offices. In 2002, I joined a local Boise CPA firm as a partner, and in 2012, I co-founded a local Boise CPA firm called Coles Reinstein, where I currently work as a partner.
And would you describe your general work history and experience for the jury, please?
Well, early in my career, my focus was on helping businesses and individuals with accounting and tax matters. As my career evolved and developed over time, I spent more time in providing planning and consulting services with businesses and individuals, and also began helping attorneys to understand the financial issues that were involved in disputed matters that they were working on.
And would you describe any specialized training you've received?
Over the course of my career, in addition to the general tax and accounting continuing education that I've had about 2,000 hours of training specifically related to understanding business operations, projecting business earnings, and identifying and evaluating risk factors that affect businesses.
Have you had experience in working with or analyzing the financial operations of hospitals or other healthcare providers in the past?
Yes, I have. Over the course of my career, I've provided a variety of accounting and tax services for medical organizations and individual professionals. I've also been involved in providing business valuation and consulting services to medical organizations. So an example of that would be if one medical organization is going to merge or acquire another organization, the consulting would relate to the issues involved in that business activity.
Over the course of your career, has your testimony as an expert witness generally been oriented to plaintiffs' matters or defendants' matters?
Well, it's been a while since I've actually made a specific list, but several years ago when I did, it ran about 50-50 plaintiff and defense, and I have no reason to believe that it's changed since that time, so approximately half and half.
Okay. And just to be clear, who retained you to testify in this matter?
It was your firm, Holland & Hart.
And when were you first contacted to assist with this analysis you performed?
It was in the fall of last year.
And would you just explain to the jury in general terms what you were asked to do?
I was asked to assist in evaluating the financial impact on the St. Luke's health system as a result of the disruptions that occurred in March of 2022.
And how did you go about conducting your analysis?
I participated in a series of several meetings with Kate Fowler and other members of the finance staff or department of the St. Luke's health system. I was given an opportunity to review data that they had provided or compiled. I also asked several questions and was able to request and receive additional supporting documentation that they had prepared. In addition, I also spoke with Spencer Fomby about the impact on security costs for the health system.
Thank you. What records did you review to assist you in your analysis?
Well, there were a variety of reports, of course, that were prepared by the finance department from their accounting records. So I went through those records in detail. I took a look at the audited financial statements that were prepared by the independent outside CPA firm for the health system. I took a look at government and industry publications on the health services industry in the U.S. to get an idea and understanding of the operations. And then I also took a look at information that was prepared by the Division of Financial Management from the state of Idaho on their economic forecasts for the state of Idaho.
So, Mr. Reinstein, how did you structure your analysis in this matter?
Essentially, what I ended up doing was preparing two opinions. The first was to illustrate the financial impact of the disruptions that occurred on the business operations in March of 2022. And the second was to illustrate the impact of the requirement to provide additional or increased security for the health system in order to protect their patients and their employees.
And as part of the development of your opinions you just described, did you prepare any kind of summary of the overall financial impact on St. Luke's Health System for the items you just described?
Yes, I did.
Mr. Bullinger, would you please display the demonstrative called overview? Okay. And before we zoom in on anything, this is the overview that you were just describing, Mr. Reinstein?
That's correct.
Okay. And then, Mr. Bullinger, could you just zoom in on that lower half? There we go. Would you explain what's reflected here, Mr. Reinstein?
This is a summary of the data that was accumulated in the two opinions that I mentioned. Excuse me. The top line there that says lost earnings on the left are a reflection of the lost earnings from March of 2022 in the amount of $3,896,000. The line below that's additional security costs. That was broken into two components. The first one being the one-time cost to get the system set up, and that amount was $54,700. And then in addition, there are annual recurring costs for additional personnel of $4,640,000. So the total of those two, the one-time non-recurring costs in the first column there, total $3,951,000. The annual recurring costs are $4,640,000. And then what I did was accumulate those costs over time, calculate what's referred to as a present value. The present value of the one-time cost is the same, the $3,951,000. The present value of the annual recurring costs, so these costs that continue on into the future, are $45,447,000. So the total of those two then reflect the impact, the financial impact on the health system of $49,399,000.
Thank you. And we'll get into a little more detail in just a moment. Based on your review of the various financial records you identified earlier and the summary you just noted, reflecting the present value of losses and costs, did you prepare any schedules to support your conclusions on lost revenues, earnings, and additional costs expected for St. Luke's?
Yes, I did.
Okay. And Mr. Bullinger, would you pull up demonstrative schedule 1? Okay. And is this the first schedule in the analysis that you prepared?
Yes, it is.
Okay. And I'd like to go through these schedules with you and have you just explain the data that's presented there for the jury. So starting here with Schedule 1, would you explain briefly what this schedule presents?
So the schedule is actually broken into two parts that are separated by that horizontal line that goes across approximately in the middle. The top part reflects a summary from other schedules which are identified in the second column. So you can see at the top Schedule 2, Schedule 3, Schedule 4, and so on down. So those particular schedules provide additional details from which the data that's reflected on this particular schedule was taken. So the top part reflects the impact on earnings and expenses and the net earnings, or the net profit, if you will, from the operation of the health system. The first three columns are related to the Boise operation. The next three columns are related to the Meridian operation. And then the final column combines the Meridian and the Boise operations together, and they come down to the $3,896,000 total as the impact on the income from the health system for the disruptions that occurred during March of 2022. The bottom portion of the schedule reflects the increased security costs, which are detailed on Schedule 6 and Schedule 5. Schedule 6 shows the increase in the personnel costs of $4,600,000, and then there's $10,000 of annual recurring costs that are related to the computer systems that are used to manage the security system. So it shows the $4,640,000 as the total annual cost. Then down below that are a couple of numbers which add up to $54,700. That's the cost of the equipment, the training, to set up the procedures to get the security systems into place.
Thank you, Mr. Reinstein. And understanding Schedule 1's framework and its citation to other schedules, I'd like to move now to Schedule 2 so you can further break down the analysis of the canceled appointments.
Okay.
We're there. Okay, so here on Schedule 2, Mr. Bullinger, first, would you zoom in on, I think, the top right box? Okay. And Mr. Reinstein, would you briefly explain what this schedule presents, and particularly this part that's highlighted?
Okay. Well, there were 4 boxes here, and so those were the 4 operating units. And each box has basically the same information, but the objective here was to determine what were the normal cancellations that occurred during time periods other than the week that was affected by the disruptions. And so what this particular schedule here shows the cancellations that occurred between February and April, so that's a period of 12 weeks for the Boise clinics. And this is just cancellations. And what we're trying to do is determine how did the disruption impact the cancellations? Was there an increase in the level of cancellations during the week of disruption? The day of the week shows the days that were relevant here, Saturday through Friday, and the dates that are reflected are the specific dates of the activity in March. The next column to the right says average normal cancellations per day, and so on a Monday, a given Monday, outside the disruption time period, again, I mentioned there were, from February to April, we're talking about 12 weeks. So these are averages for 11 weeks, not including the week of the disruptions. So on a given Monday, there were 482 cancellations. When we compared that to the cancellations during the week of the disruption, so that would have been Monday, March 14th, the cancellations were 550 that day. So the final column to the right that says variance shows the increase in this particular case in the cancellations on that Monday. So we averaged 11 weeks at 482. We looked at the 1 week, which was March 14th, at 550, excuse me, and came up with the 68 additional cancellations. Now, these particular clinics were closed on Saturday and Sunday, and so the first 2 lines showed 0 amounts or blank amounts, and that's why, because those clinics were not open at that period in time. But as you proceed down the schedule, you see on Tuesday the average calculations again for the 11 weeks outside the disruption, and this is prior to the disruption and after, because we're looking at February, March, and April, were 517. The cancellations during the week were 564. So the increase in cancellations were 47. So the process continues on down, you can see on Friday, the last day, the cancellations were actually less during the disruptions. So what we did was add those days together to come up with the 227 cancellations for the week that are shown highlighted in green. And then that 227 number is carried forward to Schedule 1.
And Mr. Reinstein, I know that we zoomed in on one of the boxes so that the jury could better see. Is there anything else you'd like to highlight in this exhibit, or is it covered?
Well, I think with what you have shown there, so there's 4 green highlighted numbers, and that's the cancellations for the week. If we look at the top left, that's the Boise Hospital. The top right are the Boise clinics. The bottom left is the Meridian Hospital, and the bottom right are the Meridian clinics. And so we show the total increase in cancellations over what was normally expected in cancellations. Those are highlighted in green, and each of those highlighted numbers carry forward to Schedule 1.
Thank you, Mr. Reinstein. Let's go to Schedule 3. And would you give an overview, Mr. Reinstein, of what Schedule 3 presents?
In order to place the analysis in context, what I wanted to do was take a look at the financial activity for the entire operation of the health system for the Boise and Meridian operations. And so this data was provided that shows if you go to the left and move down the column, you see you start with gross patient revenues. Then there are some adjustments to those patient revenues. Then in about the center, there's a series of expenses. So those are the operating expenses of the health system. And ultimately, at the bottom of the page, you get down to the net income that's generated from the health system. So this is for a period of 1 year for their fiscal year 2022. If we look at the columns that move across from left to right, the first column is the Boise Hospital. The second column is the Boise Clinics. The third column is the St. Luke's Cancer Institute. And the fourth column then is simply the sum or the total of those 3. Then the same thing happens over in the fifth column. That's the Meridian Hospital. The next column to the right represents the Meridian Clinics. Those are added together to come up with what's in the next or the final column to the last there, or before the last. And then the last column, which says combined, is simply the addition of the Boise operations and the Meridian operations to come up with total revenues, expenses, and net income for the fiscal year 2022.
And just to be clear, Mr. Reinstein, are these numbers represented in the thousands?
Yes, they are. So if we look at the bottom right where it says 269,203, that's $269 million, not $269,000.
Okay. And why is it notated that way?
Well, that's common in the presentation of financial data, just to summarize or shorten the number of digits that we have to deal with.
Understood. So shall we move on to the second page?
Yes. So the second page is a summary of the key information that was extracted from the first page that we would use to carry forward into the summarized information on Schedule 1. And what we're trying to do here, the first line there says net patient revenues. So that was to identify the net revenue after contractual adjustments that was generated by the health system over the course of the year. Now that's going to be used to convert down to what is a lost appointment worth in terms of revenue. So that's the significance of that. And then we took a look at the expenses. The health system had provided salary and benefits, but it determined that information, because it wasn't impacted on a daily basis, was not relevant to the analysis. But the two items below that, the medical and other supplies and the drugs, were relevant. Now, the reason that those are relevant would be maybe to give you an example. If you have a retailer that sells shirts, as an example, and they pay $12 for a shirt, and then they sell that shirt to you and me for $20, if for a given day they're unable to operate the business and they want to know what they lost, what we would do is take a look at the operations, and we'd start with the sales that they lost. In this case, $20. We would multiply that by the number of shirts that they normally sell. But $20 is their gross revenue. That's not the net that they generate. What we need to do is look at what costs did they save by not being able to sell that product. Well, the cost that they saved was the cost of the shirt, because the shirt is still sitting on the shelf, and so they don't have to go buy another shirt to replace that one. So they have a saved cost of $12 compared to the $20 that they would have received, and so their net loss in that example would be $8. So what we're doing here with this financial information is we start with the revenues, and then the medicines and other supplies and drug supplies. Those are costs that are not going to be incurred if they don't have a patient coming into the facilities, but would be if a patient does come in. So those are costs in effect that they've saved, and so those are going to be used to adjust the overall loss. These numbers will all be carried forward to Schedule 1, and we'll be able to get into those in a little more detail in a bit.
Thank you. So at this point, can we move on to Schedule 4?
Yes.
All right. And would you briefly explain to the jury what this schedule presents?
Well, the objective, of course, is to determine what the value of a patient visit is. And a hospital provides a variety of services to patients that come in. They categorize those services generally into two types of revenue. You can see at the top the inpatient revenue and outpatient revenue. Now, inpatient revenue typically is represented by a service where a patient is going to be admitted to the hospital and stay in the hospital overnight and maybe for several days, versus an outpatient procedure or revenue is going to be typified by a situation where a patient comes into the hospital, certain procedures are performed, and they're discharged. So maybe a good example of those would be if someone came in for heart surgery, as an example, they would be admitted to the hospital and they would stay in for several days or maybe several weeks, depending on the severity of the condition. That's a good example of an inpatient revenue. Versus if I cut my hand and I decide I need stitches, and so I go to the emergency room, the doctor puts in stitches and observes me for a little bit and then sends me home and says, don't do that again, be careful. That's a good example of an outpatient procedure because I was only in the hospital for a certain period of time. And so what needs to be done here is that we take this information, we compare it to patient visits. The inpatient revenue, of course, is going to generate a lot more revenue per patient than the outpatient revenue because it's a more intensive procedure, the heart surgery versus the stitches that were put into my hand to solve my problem. So what we do is there are some factors that are calculated here where we take into account acute patient days, and it's a fairly complex process, but it's one that's standard in that it's used by other institutions to estimate the value of a patient visit. That's ultimately what we're trying to do here, is take all of this revenue and convert it into how much is a patient worth to the hospital in effect on a particular visit. So ultimately, there's a factor that's calculated, and it's shown at the bottom right of this schedule, and it's $170,329. And so that factor is going to be used to convert overall hospital revenues into a value per patient visit. This particular schedule is for the Boise Hospital. There's also a second schedule, which is for the Meridian Hospital. It has the same kind of information on it. And again, the objective here is to determine what the value of a patient visit is based upon all of the different kinds of services that are provided, and whether it's outpatient or inpatient. We collectively take all those into account to come up with an average.
Thank you, Mr. Reinstein. And you gave a couple examples, of an inpatient and outpatient type visit, but outpatient visits do also include, more costly services, potentially MRIs or cancer treatments, those sorts of things?
Yes, that's correct.
Okay. And so that's all factored, or that's all part of the factor that's going into this analysis?
Yes, it is.
Thank you. Okay. Have we now covered all of the schedules related to the lost patient revenues and earnings addressed in your opinion 1?
Yes, we have.
Okay. So let's move to opinion 2. And as a starting point, go to Schedule 1. Okay. And would you give a brief overview, Mr. Reinstein, of your opinion 2?
Well, you had Schedule 5 up there, and that was actually the first schedule for opinion 2.
Oh, my apologies. I thought we were going to the general overview. So back to Schedule 5, please, Mr. Bollinger. Okay. Now please proceed, Mr. Reinstein.
So again, opinion 2 deals with the increased security costs that the hospital believes are necessary to protect patients and staff. So one of the elements of that was to look at what the cost to establish or set up the security program would be. There were 5 columns going across the top to the far right side: the taser, the body camera, the drone program. So these are examples of the costs that were necessary to develop the security system. The column to the left that says total costs represent just the summation of those costs in the other columns. Then there's the security program implementation. So we come up with a total cost of $54,000 to install or to get the security system set up.
And Mr. Reinstein, just to step back for a second, does your expertise extend to matters of physical security for business operations?
No, it does not.
So what is the basis for the information provided in this schedule?
Well, this is data that was generated by St. Luke's Director of Security, and then I understand was reviewed by the security consultant that they hired, Spencer Fombie. And so what I did was simply looked at their information. I spoke with Mr. Fombie, and then I summarized the costs that they had in their detailed schedules to come up with this analysis here. So my role was just to summarize information that they had put together based on their expertise.
Okay. And what is your overall cost conclusion?
It's the total at the bottom, the $54,700.
Okay. And is this cost an annual recurring amount or a one-time cost?
It's a one-time cost.
Okay. Let's go to Schedule 6. And before we zoom in on anything, Mr. Reinstein, would you please explain what Schedule 6 represents?
Schedule 6 is an analysis of existing security personnel spread out across the various facilities that are operated by the health system, compared to the additional needs for personnel that the hospital believes that they're going to have hire or have hired in order to provide adequate protection for the patients and the staff.
Okay. And how did you obtain this information, Mr. Reinstein?
Well, this information is my understanding that the initial data was gathered by the Director of Internal Security. It was reviewed by the external consultant, but the details that are reflected here were developed by the finance personnel of the health system.
Okay. And one more overall question. what's reflected in this schedule relates to not just the Boise and Meridian facilities, correct?
Right. It reflects the health system overall,
Okay.
all of their locations.
And Mr. Bullinger, could we zoom in on, and you could just, I think, start at the left, and then we'll just pan across. I think that's the best way to zoom in. But on the section that addresses the information station assistance. Okay, there we go. And Mr. Reinstein, could you just walk us through what is reflected at that line 0266 information station assistant, and then we'll pan to the right.
Well, the security analysis is broken down into functional capacities, if you will, and so that's what the information station would be. When you show up at a clinic or a facility, there generally will be a person there that asks why you're there and will help you to figure out where you need to go. Over to the next column to the right represents the location of where the individual will be stationed. And then as we move over further, let's look at there are 4 columns there. So the first column, which shows the 12.7, and underneath the solid line shows 22. That's the number of security personnel that were in existence in September of 2021, so before the disruptions occurred. The next column to the right, so if we go from the 12.7 to the 23.8, that's the personnel that they now believe they need in that position at the Boise Hospital. So if we move on down the schedule, each one, hang on just a second before just go ahead and stay right there. So each location is shown by a separate line. and if we get down below the total there again, 22 personnel, that's the number of people that they had in those positions in September of 2021. Based on the projections that they prepared, they now believe they need 79.8 people. Now, the reason it shows as a fraction, and these are FTEs or full-time equivalents. So if you have a person who works full-time, that's 1 FTE. If you have a person that works half-time, so they do, say, security half-time and do something else half-time, they're 0.5 FTE. And so that's why there's a fraction here. So again, in September of 21, they had 22 full-time equivalents. Now they believe that the requirement will be to have 79.8 full-time equivalents. The average cost, which is the next column over, 2171, that's the salary or the wage that's going to be paid. So it's $21.71 per hour. The next column to the right, the 57.8, so that's the additional full-time equivalents that they're going to need for that position. So that's simply the 22 that they had in place prior to the disruptions, and the 79.8 that they will have in place as a result of the disruptions. That's an increase of 57.8 positions. So now if we can move further to the right. There you go. So the total cost then for those 57.8 additional positions is going to be $2,611,591. That's the salary, the payroll costs that they're going to incur. The health system pays benefits or has costs related to payroll. So payroll taxes, medical insurance, retirement, those kinds of things that increase the wage cost. And those amount to approximately 25%. So to give you just a quick example, if you're paying someone $100, when you add on the benefits, it's going to actually cost $125, 25% in addition. And that's what we're doing here. We take the $2,611,000, increase that by 25%, and so the total cost with the benefits then amounts to $3,264,488. So that's the total cost for those 57 additional FTEs for the information station.
Thank you for walking us through that. And just to be clear, these 57.8 additional FTEs are actually in force, based on your understanding, correct?
Yes.
Okay. So if we could zoom back out again, and I think go down to the next page, Mr. Bullinger. Mr. Reinstein, what was your overall cost conclusion?
The overall cost conclusion is the number that's highlighted in green there, which I'm having a little trouble. There you go. $4,630,203. And so that's just a summation. Each of those sections on the 2 pages goes through a similar process to what I just described and shows what personnel were, what personnel are now, what the cost is, plus the benefits to come up with the total cost. And then when you add all those together, you come up with that $4,630,000. It's highlighted in green. That's the number that's going to be carried forward to Schedule 1.
Okay. And is that $4,630,203 an annual recurring amount or a one-time cost?
It's an annual recurring cost. So these are permanent additional security positions. So the health system is going to have to pay that amount every year.
Thank you. So now are we ready to go back to Schedule 1, to this overview?
Yes.
Okay. So Schedule 1, Mr. Reinstein, at this point, what would you like the jury to know about the schedule?
Well, so now we've gone through the supporting schedules, and I don't know if you can highlight that just a little, or expand that just a little bit to make it, well, not just so I can see the whole schedule. Maybe that's as big as you can get it at that point. There, thank you. So on the very top line, on Schedule 2, we talked about canceled appointments. And so what this reflects, you may recall, we went through the Boise clinics in some detail, and they had 227 canceled appointments when we compared the 11 weeks average before and after the disruptions to the week of the disruptions. There were 227 canceled appointments, so we lost those appointments. The hospital had 4, so those add together on the top line there to 231. The same thing for the Meridian Hospital and Meridian Clinics at 65 and 330. So the total canceled appointments for the Meridian operations were 446. The final column out to the right shows 677 total canceled appointments, over and above what normally they would expect. So then the next step in the process here is to determine what is the value of each of those canceled appointments. How much did the hospital lose as a result of that patient not showing up for whatever procedure it was going to that they had originally decided they needed? So the second line, Schedule 3, shows the gross revenue or the total revenue that was generated by the health system for their fiscal year 2022. But what we need to do is convert that into what's the value of a canceled appointment. And so you may recall I talked about some factors in Schedule 4, and one of the factors was the $170,000 for the Boise clinics. That was based on the inpatient revenue, outpatient revenue, the number of patients that were going to show up, and the various ratios that were calculated to come up with a number which we can use to calculate an average. So that $170,000 gets divided into the total revenue. So again, this is not the lost revenue, but just the total revenue. And that comes up with a number which is shown in the third column there, the $8,714. That's the value that's associated with each visit to the hospital. So it's the loss that the hospital would suffer as a result of a patient canceling an appointment. There were 231 appointments canceled, so if we take that $8,714 times the 231 appointments, it means the hospital lost revenue of $2,013,830 that would have been expected if those 231 appointments had followed through and not been canceled. The next couple lines below that, we talked about on Schedule 3, the medicines and supplies and drugs, and I use the example of a retailer that sold shirts and indicated that they would save the cost of the shirt. If they weren't able to sell the shirt is still on the shelf, they've saved that cost. And that, again, is similar to what we're talking about here with the supplies and the drugs and medicines. Since the patients didn't show up, they didn't have to administer those kinds of things, so they saved that cost. So those lines represent the total costs, again, over the entire year. And those costs statistically or historically run 27.9% of revenue. And so what we do here mathematically is we take the $2,013,000 in revenue that was calculated. We then multiply that by 27.9% to show that they've saved $561,000 in drugs and supplies because they didn't have those patients show up for the hospital. So we take the $2 million of revenue, subtract the $500,000 in saved costs, and so the net loss for the Boise Hospital and Clinics is $1,451,835. We go through the same process in the next to the last column, and I won't go through all the details, but the fourth line down shows that the average patient revenue for the Meridian operations is $6,714. So it's a little bit less than the average revenue per patient from the Boise Hospital. There were 446 lost or canceled visits there. So we go through the same process. We end up with lost income from the Meridian operations of $2,444,958. So those two numbers are added together, then that's how we arrive at the $3,896,793. And I think it's important to point out that this is a standard methodology that's used by professionals that do this type of analysis, whether it's in this situation, particularly for the hospital, or it's in a business that has an interruption from a fire or a flood or some other kind of event that affects operations. They would go through a very similar process of determining what are the lost units, what is the revenue per unit, what are the relevant expenses to that, to generate that, to come down to the loss. So this is a generally accepted process in the industry to develop this kind of loss analysis. The second part then again is the security costs. On Schedule 6, there was a 2-page listing of the existing and the additional security personnel. And so this $4.6 million that's reflected there represents the cost of the additional security personnel that are going to be required. In addition, there's the $10,000 cost that's going to be recurring annual cost along with the salary of $4.6 million. So the total cost for ongoing additional annual costs are the $4,640,203 related to security. The items below that are the $54,000 was the cost of the equipment and training and so forth in order to get the security system set up and into place.
Thank you. So, Mr. Reinstein, we began your discussion of the financial data you'd accumulated by reviewing a section or a demonstrative that was titled Overview. So was Schedule 1 the source for that presentation?
Yes, it was.
Okay. And would you briefly show the jury how Schedule 1 and the overview relate to each other. And I would ask, I suppose, whether you want to stay on this or move to the overview.
Well, we can just talk quickly about the key numbers, excuse me, that will come to the overview. So in the center, to the column to the right, the $3,896,000, that's going to come forward to the overview. The $4,640,000, that's going to come forward to the overview. And then at the bottom of the page, the $54,700. And so if you want to then put the overview up, I can show how those relate.
Mr. Bullinger, would you go to the overview? Thank you. And then zoom in on that same portion we were on before, just so the jury can see. Okay.
So again, we've gone through in Schedule 1, the summary, which compiled the details that were developed in Schedules 2 through 6. And then that information from Schedule 1 carries forward to this overview analysis, if you will. The $3,896,000 in the top left, the $54,000 right below that. So those are the one-time costs that are going to be incurred. And those total to the $3,951,000. To the right of that, in the column labeled recurring annual costs, that's the payroll and the security system annual costs, which total $4,640,000. And then again, to accumulate those, the one-time costs, as the name implies, are just one time, and so there's no future adjustments that's necessary. So in the box, the horizontal box at the bottom, the total of $3,951,493 is the total for the one-time costs. The total for the present value of the ongoing costs, when those are accumulated over time, is $45,447,630. And then again, the overall impact on the health system is the $49,399,123.
So as I understand your data, it's the present value of losses and costs that are relevant to your financial conclusion of the overall financial impact on St. Luke's. Is that correct?
Yes.
And could you explain how the present value calculations were developed?
It was based on a schedule that I prepared.
And was that Schedule 7?
Yes.
Okay. Could we go to Schedule 7, please, Mr. Bullinger? Okay. And would you...
Counsel, I'm just going to stop you.
Oh.
Do you have much more, or is this the last point with this witness? Because we're at 10:30.
We have just a little bit more, but it's going to be more than a few minutes.
Okay. So make a note where you're at. Ladies and gentlemen, we'll take our morning break, 15 minutes, and then we'll come back and finish with this witness. Over the break, heed the admonitions of the court previously given. No deliberations.
All right.
Continue.
Thank you, Your Honor. So, Mr. Reinstein, when we left at the break, we had just opened Schedule 7. Is this the schedule that you referred to earlier that you prepared?
Yes, it is.
And does this schedule only apply to security expenses, or are there other costs involved?
It only applies to security expenses because when you do a present value analysis, what you're doing is converting future costs into today's dollar value. And so only security costs are the ones that are going to continue off into the future.
Okay. So how does the calculation of the present value of those costs affect your analysis?
Well, essentially, the present value is a concept.
It just went off. Mr. Clerk, can you check that microphone, please?
Is that it? Hello? Okay. So the present value is a concept where you convert future costs into today's value. It's oftentimes done in the court setting because you don't want to come back every year and revisit the costs and determine a new award. So the court needs to know what is the value today. But that's similar to a process that a business would go through when they're conducting a multi-year expansion project. As an example, Micron out here is undertaking a project to expand their plant facilities. And I'm sure they projected what the costs are going to be each year, but they also have had their finance people convert those to today's dollars so they know how much money they need to set aside in order to fund the project. So that's very similar to the process here in calculating a present value.
Thank you. And Mr. Bollinger, could we expand the top portion initially? Thank you. Mr. Reinstein, could you remind us where the annual costs that are reflected there come from?
The $4,630,000 is the payroll cost, and so that came from Schedule 7. And the $10,000 is the annual subscription cost for the computer programs. That came from Schedule 1.
And then, excuse me, I see some percentage amounts there on the screen on Schedule 7. Can you explain to the jury what those are and how you use them?
Yes, in any present value analysis, you have to develop factors that are applied against the future costs. And maybe to give you an example which might help to clarify how this would work, let's say that you were going to borrow $5,000 from a bank, and you and the bank agreed that it would be repaid over 10 years at 10%. Well, you would pay approximately $800 per year to service that loan. So over the 10 years, you would pay $8,000 on the original $5,000 loan that you took out. So essentially, the $800 a year that's being paid in the loan payments are very similar to what we see here with the $4,640,000 in annual costs for security. And so we know what the future costs for security are going to be. We have these percentage factors. What we need to do then is somehow convert that into present value, or the analogy would be in the bank loan, the $5,000 is the present value, the $800 a year accumulating to $8,000 is the future value. And so by applying the percentage calculations, we come up with the present value analysis here of $45,447,630.
Is there anything further to explain on this top portion before we move down to the lower?
No, I don't think so.
Okay. Mr. Bollinger, would you zoom in on that lower half? Okay. So the bottom portion of Schedule 7 contains reference to years and several columns of numbers. Would you explain what those represent?
In most applications, financial applications, there's two different ways to go about performing a calculation. So to give you an example there, say that you have a teacher who's teaching 10 students a day, 3 days a week. And so you want to know how many students does the teacher teach per week. Well, there's two ways that you can go about calculating that. We can add the 10 students from day 1 to the 10 students from day 2 to get to 20, and then add the 10 students from day 3 to get to 30. Or alternatively, we can say, well, there's 3 days, there's 10 students per day, so we can take 3 times 10 and we end up at 30. So we get the same answer by using either mathematical calculation. The first calculation that I talked about, where I had the $45 million present value on top, that was based on a summarized calculation of present value. What's illustrated here in this schedule is a detailed schedule of present value where you take the calculation year by year and add them together. Both of the schedules will produce the same result, but the second schedule is going to take a lot longer, a lot more work to accomplish that process. But it does have some benefits in that it gives you some benchmarks along the way. So briefly here, the $4,640,000 that's across from year one, that was the first year cost for the payroll and the computer system cost. And if we do the present value calculation, that comes out to $4,062,869. So if we go down year by year, the annual cost is going to increase 4% because that's the inflation factor that we've used. The present value calculation, as you can see, decreases each year in the middle column. The final column to the far right, called the cumulative present value, just shows the present value by adding year one to year two, then adding year three and year four, and so on down the schedule. Now, if we continued this schedule out for a long period of time, as noted at the bottom of the schedule, we would end up with the $45,447,000. But I stopped it at 20 years because I thought that was a adequate illustration of the way the two methods work. And after 20 years, we've accomplished 85% of the present value. The number at the bottom right, the $38,463,000, is 85% of the $45 million. And again, if we continued that on, we would come up with the same answer. So this is just a second type of illustration to show on a discrete year-by-year basis how the present value calculation works.
Thank you. And to be clear, your opinion is that the actual total of the increased security costs is the $45,447,630?
That's correct, yes.
Okay. So what if the jury believes that the cost should be limited to a fixed number of years, that's something less than what's depicted here up to the year 20?
Well, and that's the reason that this particular schedule was prepared, so that the jury or the court could decide that after any number of years they want to stop the losses, and then what are the losses at that point in time. So if you use the cumulative present value number in the far right column and you go down based on the number of years, you can make a selection of the dollar amount.
So just for the sake of illustration, could you walk us through say if the jury were to determine year 5 was where they wanted to stop?
So year 5, you would go down to the fifth line, which if you move across to the right to the final column, you'll see the number is $16,992,716. So what that means is if the future costs would stop at that point in time, the $4.6 million would stop after 5 years. The present value today would be the $16,992,000.
Okay, and then the jury could, or whoever's determining the number of years for these increased security costs could then just look at any one of these years, look across to the far right column and determine that amount?
Yes, that's correct.
Okay. So in creating this table, Mr. Reinstein, are you advocating a shorter period of time or just providing an illustration?
I'm just providing an illustration. I thought 20 years filled the page, number one, but it was also a time point when it reached 85% of the costs. And so my thought was that if the court decided that something more than 20 years was appropriate, then it probably just makes sense to use the normal present value calculation, which yields the $45,447,000. But if in the event the court decides that a lesser time period, then what this schedule illustrates is you can stop at any point in time up to 20 years, and I've calculated the number for you that you would use.
So just to be clear, counsel, the witness is referring to the court making a determination. The determination of damages will be determined by the jury, not the court, as to this request.
Thank you, Your Honor.
I'm sorry, Your Honor. I meant the jury, but...
Not a problem.
Thank you. So at this point, Mr. Bullinger, can we go back to the overview demonstrative? and then zoom back in on that same section we've been focused on. Thanks. So, Mr. Reinstein, are the amounts reflected in the overview section of your report representative of your financial conclusions in the matter?
Yes, they are. The box, the horizontal box at the bottom of the schedule that says present value of losses and costs is my final conclusion. Okay.
And can you recite for the jury what that total is?
The combined one-time and annual recurring costs have a present value of $49,399,123.
And then just to refresh us, why is that different from the $45 million number that's there?
Well, the $45 million, again, is just the present value of the security costs. Once we calculate the present value of the security costs, we have to add the present value of the losses in operations, which are the $3.9 million. So when you add those two together, those two components, you come up with the $49 million.
Thank you. And to be clear, the $49 million number is expressed in terms of today's dollars, correct?
Yes, it is.
I have no further questions for this witness.
Counsel, can you approach?
I realize you used his schedules as demonstrative exhibits. I have no idea if these raised in really good notes how they would have those numbers before then if they decide a number shorter than the 45 million or the 20 years or less. I mean, how will they remember that? That is, but this seems to be a critical exhibit that I don't see how the jury could have copied down all those different present value calculations. It seems like we would just potentially be getting a question maybe from the jury. So I'm not sure how you want to proceed. Well, an expert report and schedules are two different things. So I don't know that all the schedules need to be admitted, but I just don't understand how the jury can keep track of all this, the present value. The rest they could, I think. Well, because these two documents are in, so I think all he needs is the present value calculation.
Couple further questions. Mr. Reinstein, I think we've already established that Schedule 7 was what you prepared as the present value calculations on the increased security costs, correct?
Yes, it was.
And the Schedule 7 that we were just viewing and walking through is a true and accurate copy of the schedule that you prepared?
It is, yes.
Thank you. Your Honor, I'd move to admit Schedule 7 into evidence.
How do you want that marked, counsel?
Exhibit 900.
Ladies and gentlemen, the court is going to admit Exhibit 900. It is a summary of the witness's calculation that you may or may not agree with, but I'm not sure that you could remember those numbers potentially unless you had that exhibit. So I'm admitting it as a summary exhibit under 106. And it's up for you to put whatever weight you wish to put on Exhibit 900. It is admitted. Now, may this witness be excused.
Yes, Your Honor. Thank you.
Thank you very much. Mr. Stidham, can you approach now? I just want to check with you. You didn't go over all the documents in the binder, did you?
No.
Thank you. Nope. I may or may not have cited the correct rule for that summary. I'm admitting it under Rule 1006. All right. The plaintiffs may call their next witness.
We have no further witnesses, Your Honor.
Plaintiffs rest?
Yes, we do.
Okay, thank you. The plaintiffs have rested in this case. I do need some time to finalize the instructions with counsel. Is there any objection to excusing the jurors and having them come back at 2:30 for closing arguments?
No, Your Honor.
I think that would, when? Lunch will still be brought here at noon if you want to wait and get the lunch. Thank you, Mr. Clerk. We did bring in lunch for you, but it's going to be a little bit of time, plus I want to give counsel a break before we go into the court reading the closing instructions as well as having closing arguments. So it's going to be a longer break today, but we will get to closing arguments. It's very important during this recess that you not discuss the case, do not begin deliberations. The case has not been submitted to you. So over this lunch break, so it's 11:15, so we will have you back here at 2:30, and we'll have closing arguments at that time. All right? Thank you very much.
All right.
All right, please be seated. Counsel, I realize that since we met this morning, you've been busy doing other things. So I want to give you an opportunity to review the court's proposed revised closing instructions and revised special verdict form where we incorporated some of Ms. Jensen's comments. Review both of those and then come back on the record. How about if we come back on the record at high noon and make a record regarding the closing instructions and the proposed special verdict form of the court. After I rule on any objections that may exist on either of those documents, or if I agree as to additional modifications I want to make, we will then make modifications, then you can have your lunch break, and then you can come back being prepared to argue at 2:30. Additionally, in between this time, I know your staff has been working with my clerk, but there were a lot of exhibits that had some minor redactions to them, and I just need to make sure that all those documents that are being admitted are consistent with the court's order. And then the other item is if there's been any decision by the plaintiffs to reduce Exhibits 1 and 2 to the relevant medical records that were actually discussed in this case.
There has been, Your Honor.
And what is your position?
We are reducing it, and I think we've got that fine, Your Honor. We just need to get it. I think we're ready to do that.
All right, so they've already been reduced? Okay. And I haven't reviewed the reduced ones, so I'm trusting that your staff and you have made sure that they are adequately redacted and reflect the documents that were shown and or discussed in this case.
Yes, Your Honor, we had staff and an attorney reviewing yesterday.
Okay. So other than Exhibits 1 and 2, are there any other exhibits that are being shortened, reduced in size? I mean, 351 you said you wanted to keep intact. Any other exhibits that you've considered reducing?
No, Your Honor.
Well, you've considered, but there just aren't any other exhibits. Okay.
Thank you for the redo, Your Honor.
No, that's fine. Additionally, I want to make a finding at this time. So typically, when I have a case where parties are seeking punitive damages, because punitive damages are within the discretion of the trial court always has the opportunity, even if it's a matter to be determined by the jury, to determine whether after hearing all the evidence, the court should allow punitive damages to go to the jury. I recognize that I adopted Judge Norton's legal analysis in her written order that punitive damages may be considered by the jury for the defendant's conduct. But I also feel like I need to exercise my own discretion after having heard the evidence to make a finding as to punitive damages. In exercising my discretion, I've considered the standards for exercising my discretion under Lundberg v. My Fun Life. But based on the evidence that I've heard at this trial, the court is going to exercise its own discretion and reaffirm Judge Norton's written ruling that punitive damages may be considered by the jury for the defendant's conduct. There is substantial and competent admitted facts as well as other evidence that could support a punitive damages award for oppressive, fraudulent, malicious, or outrageous conduct by the defendants. So that question will be submitted to the jury to decide as to each plaintiff whether they're entitled to punitive damages and as to each defendant whether that defendant is being held responsible for punitive damages. So it'll be an independent finding for each plaintiff and for each defendant in this case, and that will ultimately be decided by the jury. Additionally, in this case, in the prayer for relief, there is a request for injunctive relief, and the court will only consider that request for injunctive relief after I have the verdict of the jury as to the other claims. But regardless of the jury's verdict, I do intend to act on that, but I will put weight on what the jury finds on the other claims. The last point is the mountain of paper behind me. Certainly, I don't have any need if we have the admitted copies. So all these are going to go back, and there will now be an adequate supply of binders in Boise for other people to use. So I really appreciate you creating the separate witness binders. To me, that was very helpful. I think it was also helpful to the witnesses, but we're simply not going to maintain all these documents. We will maintain the admitted exhibits, and that will be it. So, noon, review my proposed instructions and special verdict, and be prepared to make any objections that you may have. Anything else?
No, Your Honor, nothing else.
Okay, thank you very much. The court will be in recess till noon. Counsel for St. Luke's in-house are present. The rest of the parties are not. I don't think that's required since this is a legal matter on the instructions. The court has provided its proposed instructions, and I wanted to make a comment. We had talked about the court doing something different on the punitive damages instruction, which is instruction 30, and we went back to the model instruction because upon my review of the fourth amended complaint, I don't know that all the facts of the 4 ways that you can find conduct rising to the level of punitive damages has in fact been established. So I'm going to leave that to the jury. So it's just the model instruction, and I think we sent it out that way even though we had discussed something differently this morning.
Yes, Your Honor. I understood that to be the case based on the vote made on record.
Okay. So there's a couple typos. Do you want to just go through the instructions, or do you want to tell me your issues, and we'll see if we can informally resolve them?
Well, Your Honor, we actually didn't have anything substantive, just saw a handful of typos.
Okay. So then I'm gonna start at 10, and you can just tell me if you have an objection, or 11. So 11 is you've heard all the evidence, no objection.
No objection.
12 is as members of the jury.
No objection.
13 is consider each count and defendant separately.
No objection.
Okay. 14 is St. Luke's Health System.
No objection.
Okay. On 15, I was wondering if we still need that since the requests for admissions were not entered into the record.
We agree, Your Honor. Given that we determined not to submit any requests for admission into evidence, we no longer need the instruction.
So proposed instruction 15 is withdrawn.
Yes, Your Honor.
Okay. We can either renumber or have a gap. It doesn't matter to me. We have time to renumber.
Yes, I wrote the template, but I can remember it.
Okay. Adverse inference instruction. Any objection?
No objection.
Okay. Causation was your proposed instruction. Any objection?
No objection, Your Honor.
Defamation. What we did is we merged the 2 instructions. If the jury found that St. Luke's was a public figure, we just said they'd have to find malice, and malice has been deemed admitted by the second amended or fourth amended complaint.
We understand, Your Honor. No objection.
Okay. Defamation definitions.
No objection.
Defamation damages.
No objection.
Invasion of privacy.
No objection.
Invasion of privacy damages.
No objection.
Okay. Intentional infliction of emotional distress.
No objection.
Okay. And damages on that claim.
No objection.
Okay. 25, we weren't using all of our fingers as we prepared this, so it should say 1, 2, 3, 4, and 5. And on 3, I'm changing it from St. Luke's did not consent to Ammon Bundy or Diego Rodriguez, in case they had different verdicts.
Yes, sir.
They don't have to find both. And then it was just changing the numbers and adding an S to counts at the top.
And additionally, the statutory has a typo in it in the title. In our version, anyway.
That's where we're going during this conference. Just kidding. All right, we'll fix that. Okay, and we continued that onto the next page. S for counts, fixed statutory on instruction 26. Anything else on the 2 instructions on trespass?
Nothing further, Your Honor.
And as previously noted, if the actual damages would come out below 500, then the court could modify that verdict. Count 7, any count 7 and instruction 27. Any objection?
No objection.
And 28 on the violation of the Charitable Solicitation Act.
No objection.
Okay, civil conspiracy. Any objection?
No objection.
Okay, punitive damages. No objection to that instruction, which is the model. Okay. And consideration of wealth.
No objection.
Cautionary instructions.
No objection.
And compilations.
No objection.
Redactions.
No objection.
Any objection to the court's implicit bias instruction?
No objection.
Evidence admitted for limited purpose.
No objection.
Communications with the court.
No objection.
And concluding remarks.
No objection.
As to the instruction about a post-verdict instruction, I just read that to them. I don't actually make it a copy of the jury instructions, telling them their options to discuss or not discuss the case. Now let's go to the special verdict. So I had my judicial assistant see if she could answer all the questions. She couldn't until she got to 10. 10 was confusing to her. So, before we get to 10, and we'll talk about how I kind of reworded that, and maybe, I don't know if Dan sent that out or not. Any objection to the special verdict form until question 10?
No, Your Honor. There was a typo in the footer, but that's not an objection. But no objections.
The third?
Correct.
Gosh, I thought we removed that last night. Okay, maybe we went back to this verdict form and we removed it on the other one. Okay, thank you for catching that. Okay, now 10 is the punitive damages for the counts they don't find support punitive damages. So identify the claims. I changed to please write down the count or counts in parens with or S in parens, and the corresponding plaintiff or plaintiffs for which the conduct does not support, and I'm going to underline not, your punitive damages award, but the question from the judicial assistant is like, do I write a sentence? What do I write down? Because we've used counts instead of claims. So we gave a little bit more room for writing. Do you have any other suggestions that might make that easier for the jurors to follow?
I guess one other thought is if there was a column for the count and a column for the plaintiff, but I don't know that really. I mean, the question does say, the count and the plaintiff.
We could put count and in parens number and title, or just the number?
Like in columns?
Yeah.
I'm indifferent. I think either way works.
So you want a count and a plaintiff? Is that what you'd like?
Yes, Your Honor.
So I think then we'd maybe do up to 4 lines. They could find no as to every plaintiff.
That was my, when I originally submitted the edits this morning, that was kind of what I was thinking, that this question might be just a second form that's given to the jury. In the event that they did answer no, as to any defendant under question 9, because then we have an idea of a little bit more of an idea of what the further information we need would be. But
Well, let's try it. If we could get a question, we could clarify it in an answer from the court that says, and give an example I don't really want to give an example, but we could say, as to count 12, even though there's no count 12 or something, and plaintiff Jane Doe or something like that. But the judicial assistant did seem to say, okay, now I know what you're asking me to write down.
Once it was count versus name.
Yeah, write down the count and the corresponding plaintiff's name. Let's add name in there for which the conduct, and then we'll put count and plaintiff, and we'll put 4 lines per 4 possible plaintiffs. Does that make sense? Okay. And then obviously we had 2 signature lines and dates. Any other typos or other corrections that you see on the special verdict form?
No, Your Honor.
Okay. So this is your chance, and when I'm reading this, if we catch a typo, we'll correct it before we print off the copies for the jurors. But the jury instructions will be up on the screen, and I'm also going to read the verdict form. I think it's part of the instructions in this case. So once I get to I guess I'll just read it after 38. So my practice is to read all of the closing instructions before I go to closing argument. But I just want to make a final record, understanding that you can bring typos to my attention still. Do the plaintiffs have any objections to the court's revised proposed closing instructions?
No, Your Honor.
Any objection to the court's failure to give a proposed instruction?
No, Your Honor.
Okay. As to the special verdict form, any objections to the revised special verdict form?
No, Your Honor.
Or failure to put a question on the form?
No, Your Honor.
Okay. Then I think we've made the record, and do you want hard copies? Are you putting hard copies up on the screen? Do you want it, once Dan gets the corrections, to be emailed to you?
Appreciate that, Your Honor. If you could email it, that would be great.
All right, so we'll make those corrections, email it to counsel. And you're still anticipating about an hour?
Yes, Your Honor.
The next question becomes, what's your preference on deliberations? Do we want them to deliberate until a certain time tonight? Or leave it to them on how long they want to deliberate? Or tell them go until X time and come back Monday morning?
My inclination, Your Honor, would ask them to go until at least 6, and if they wanted to continue, we would have no objections.
Okay.
But that's just our thought, Your Honor. But if you feel strongly another way, we would be willing to do that.
I usually leave it up to the jury and see if they want to go beyond, since it's a weekend. If they decide they want to go home, I'll have to call them in, and you'll need to be present as I admonish them for any break. But I think we just take it one step at a time, and maybe at 6 o'clock check with them
I think that would work fine.
if they want dinner brought in or not. Okay. Then I think we know how we're going to proceed, and we've got all the exhibits, Mr. Clerk. Okay then, 2:30, start with instructions and then move directly to closings. Thank you very much. Actually, I'm not leaving quite yet.
Oh, since we have a ways to go, before 2:30, I'm gonna ask everyone to leave the courtroom. Obviously, it's kind of, you can grab your paperwork.
make one more copy. Counsel, I just want to put one more thing on the record about sealing medical exhibits. Can you do a proposed order that, as to any exhibit you're requesting I seal after the trial?
Yes, Your Honor.
Thank you. Corrected version. Any other issues?
I don't think so, Your Honor. I think we're all set.
Okay, very good. Then the jury will be coming in. Christy, slow me down if I get going. Give me the evil eye. Huh?
All right.
Thank you. Please be seated. Ladies and gentlemen, did anything happen over the recess to affect your qualifications? Seeing none. All right, at this point, the plaintiffs have rested, and I'm going to read the closing instructions. The opening instructions, along with the closing instruction, each of you who are deliberating will have a complete set of the instructions. So I am going to start at instruction number 11, and it's on your monitors as well. Instruction number 11, you have now heard all the evidence in the case. The court's duty is to instruct you further as to the law. You must follow all the rules as the court explains them to you. You may not follow some and ignore others. Even if you disagree or do not understand the reasons for some of the rules, you are bound to follow them. If anyone states a rule of law different from any the court tells you, it is the court's instruction that you must follow. Instruction 12, evidence to consider. As members of the jury, it is your duty to decide damages, if any, to be awarded in this case. You are to decide the damages from all the evidence presented in this case. The evidence you are to consider consists of 1. Sworn testimony of the witnesses, 2. Exhibits which have been admitted into evidence, and 3. Any facts deemed admitted. Certain things you have heard or seen are not evidence, including 1. Arguments and statements by lawyers. The lawyers are not witnesses. What they say in their opening statements, closing arguments, and at other times is included to help you interpret the evidence, but it is not evidence. If the facts, as you remember them, differ from the way the lawyers have stated them, follow your memory. 2. Testimony that has been excluded or stricken, or which you have been instructed to disregard. And 3. Anything that you may have seen or heard when the court was not in session. Instruction 13. Consider each count and defendant separately. Again, each of the plaintiff's claims is separate and distinct. You must decide the amount of damages, if any, the plaintiffs are entitled to on each claim separately on the evidence and law that applies to that claim, uninfluenced by your decision as to any other count. Likewise, you must give separate consideration to the amount of damages, if any, owed by each plaintiff on each count. Each defendant is entitled to a verdict based upon the evidence and the law which applies to that defendant. Instruction 14. St. Luke's Health System Limited and St. Luke's Regional Medical Center Limited. St. Luke's Health System Limited and St. Luke's Regional Medical Center Limited are separate corporate entities. Due to their entity structure and financial organization, however, for purposes of any damages you may award, the damages may be awarded to them both collectively. The purpose of having one collective award, as between St. Luke's Health System Limited and St. Luke's Regional Medical Center Limited, is to avoid the risk of duplicative or double damages to St. Luke's Health System Limited and St. Luke's Regional Medical Center Limited. Thus, in these instructions and in the special verdict form you will receive, the two St. Luke's entities will be referred to collectively as St. Luke's. Instruction 15, Adverse Inference Instruction. Certain evidence relevant to this case is in the control of defendants Ammon Bundy for Governor, Diego Rodriguez, Freedom Man Press, LLC, Freedom Man PAC, and People's Rights Network, who, without satisfactory explanation, have failed to provide the evidence in discovery during this lawsuit. Because all defendants have failed to provide or withheld evidence in discovery, you must draw the adverse inference that the evidence defendants have failed to provide or withheld would have been unfavorable to defendants. You should therefore make the following adverse inferences. 1. You shall assume all defendants have the financial means to pay any damages you award plaintiffs in this matter, and that the defendant's financial status supports plaintiffs' claims for compensatory damages and punitive damages. 2. You shall assume there is evidence of financial transactions, contracts, and business relationships among defendants, as well as evidence of financial transactions, contracts, and business relationships between defendants and entities associated with or controlled by the defendants. You shall assume such evidence supports plaintiffs' claims against defendants for compensatory and punitive damages. 3. You shall assume all defendants communicated with other defendants regarding the conduct in this case and this lawsuit. You shall assume these communications support plaintiffs' allegations and claims for compensatory damages and punitive damages. Instruction 16, Causation. For each of plaintiffs' counts, plaintiffs must establish that defendants proximately caused the damages. Proximate cause contains both actual cause and legal cause. Actual cause is the factual question of whether a particular event produced a particular consequence. There can be more than one actual cause of a particular harm. Legal cause means that it was reasonably foreseeable that the harm would flow from a defendant's conduct. If there is more than one factor contributing to the harm, legal cause exists if the defendant's conduct was a substantial factor in causing the harm. So long as the defendant's conduct was a substantial factor in causing the harm, the intervention of a third party's conduct does not necessarily mean that legal cause does not exist. Rather, you should consider whether the defendant at the time of his conduct should have realized that a third person might so act, whether a reasonable person, knowing the situation existing when the act of the third person was done, would not regard it as highly extraordinary that the third person had so acted, whether the third person's act is a normal consequence of a situation created by the defendant's conduct, and whether the likelihood that the third person may act in the particular manner in which he acted is the hazard or one of the hazards that makes the defendant's conduct wrongful. Instruction 17. Count 1, defamation, all plaintiffs against all defendants. The following facts have been established. 1. The defendants communicated information concerning the plaintiffs to others. 2. The information impugned the honesty, integrity, virtue, or reputation of the plaintiffs or exposed the plaintiffs to public hatred, contempt, or ridicule. 3. The information was false. And 4. The defendant knew it was false or reasonably should have known that it was false. To the extent that St. Luke's could be deemed a public figure, plaintiffs must also establish defendants made the false statements about St. Luke's with reckless disregard for the truth of the statements and with malice. It has been established that defendants made the false statements about St. Luke's with reckless disregard for the truth of the statements and with malice. Instruction 18. Count 1, defamation definitions. Defamation is the communication of false information which tends to impugn the honesty, integrity, virtue, or reputation of the person or entity about whom the statement is made or exposes that person or entity to public hatred, contempt, or ridicule. Libel is a form of defamation. Libel is the communication of defamatory information by written words or by some form that has the characteristics of written words. Slander is a form of defamation by any other means. Instruction 19. Count 1, defamation damages. Each plaintiff has established a claim for defamation against defendants. You must determine the amount of money that will reasonably and fairly compensate each plaintiff for each of the following elements of damages proven by the evidence to have been proximately caused by each defendant's defamation. 1. Economic or pecuniary loss. 2. Failure to realize a reasonable expectation of gain due to reputational harm. And 3. Emotional distress and bodily harm. Instruction 20. Count 2. Invasion of privacy, Mr. Roth, Dr. Erickson, and nurse practitioner Youngman against all defendants. It has been established that the defendants placed Mr. Roth, Dr. Erickson, and nurse practitioner Youngman in a false light in the public eye by publicly disclosing some falsity or fiction concerning Mr. Roth, Dr. Erickson, and nurse practitioner Youngman. A disclosure of some falsity or fiction means that a publication or publications by defendants were materially false. Instruction 21. Count 2, invasion of privacy damages. Mr. Roth, Dr. Erickson, and nurse practitioner Youngman have each established a claim for invasion of privacy against the defendants. You must determine the amount of money that will reasonably and fairly compensate Mr. Roth, Dr. Erickson, and nurse practitioner Youngman for each of the following elements of damages proven by the evidence to have been proximately caused by each defendant's invasion of privacy. 1. The harm to those plaintiffs' interests in privacy resulting from the invasion. And 2, those plaintiffs mental distress proved to have been suffered if it is of a kind that normally results from such an invasion. Instruction 22. Count 3, intentional infliction of emotional distress, Mr. Roth, Dr. Erickson, and nurse practitioner Youngman against all defendants. It has been established that 1. Defendants engaged in intentional or reckless conduct. 2. That was extreme and outrageous. 3. Causing severe emotional distress. A party's conduct is intentional if the party desired to cause the consequences of the act or where the party believes that the consequences are substantially certain to result from the party's conduct. A party's conduct is reckless if a person makes a conscious choice as to the person's course of conduct under circumstances in which the person knows or should know that such conduct both creates an unreasonable risk of harm to another and involves a high probability that such harm will actually result. Conduct is extreme and outrageous when it is atrocious and beyond all possible bounds of decency, such that it would cause an average member of the community to believe it is outrageous. The conduct must be more than merely objectionable or unreasonable. Instruction 23, Count 3, intentional infliction of emotional distress, damages. Mr. Roth, Dr. Erickson, and nurse practitioner Youngman have established the elements of the claim of intentional infliction of emotional distress. You must determine the amount of money that will reasonably and fairly compensate Mr. Roth, Dr. Erickson, and nurse practitioner Youngman for each of the following elements of damages proven by the evidence to have been proximately caused by each defendant's intentional infliction of emotional distress. 1. Bodily harm and emotional distress. 2. Loss or impairment of earning capacity, including harm to reputation. 3. Reasonable medical and other expenses. And 4. Harm to property or business caused by the invasion. These plaintiffs are entitled to recover for a feeling of anxiety, not only for themselves but for others, that is the expected result of the defendant's tortious acts, or if the defendants intended that result. Your determination of the amount of damages for this sort of emotional distress may be affected by the fact that the defendant's conduct is intentional or reckless rather than merely negligent. Plaintiffs are entitled to damages for all expenses and for the value of services reasonably made necessary by the harm. This includes reasonable expenses for physicians, for nurses, for treatment, or hospitalization. It may also include reasonable expenses for substitute help hired by the injured person to do their work, but to the extent that claim for this is made, there cannot be a recovery for loss of time. There may be recovery for these items, although they are not yet paid. Instruction 24. Counts 4 and 5. Common law trespass and statutory trespass, St. Luke's, against Ammon Bundy and Diego Rodriguez. It has been established that 1. Defendant Ammon Bundy went upon St. Luke's Meridian location land. 2. Defendants Ammon Bundy and Diego Rodriguez went upon St. Luke's Boise location land. 3. St. Luke's did not consent to Ammon Bundy's or Diego Rodriguez's entry on the land. 4. St. Luke's requested Ammon Bundy and Diego Rodriguez leave or otherwise withdrew permission to remain. And 5. Ammon Bundy and Diego Rodriguez remained on the land after being requested to leave or otherwise having permission to remain withdrawn. Instruction 25. Counts 4 and 5, common law trespass and statutory trespass damages. St. Luke's has brought trespass claims against Ammon Bundy and Diego Rodriguez under both the common law and the applicable statute. St. Luke's has established the elements of trespass claims against Ammon Bundy and Diego Rodriguez. The damages available for trespass are the same under both claims. You must determine the amount of money that will reasonably and fairly compensate St. Luke's for its damages proven by the evidence to have been proximately caused by the trespasses. Instruction 26. Count 7, violation of the Idaho Charitable Solicitation Act, all plaintiffs against Diego Rodriguez and Freedom Man Press, LLC. It has been established that defendants Diego Rodriguez and Freedom Man Press, LLC violated the Idaho Charitable Solicitation Act by 1. Engaging in charitable solicitation, and 2. Using unfair, false, deceptive, misleading, or unconscionable acts or practices. The jury must determine the amount of damages suffered by plaintiffs due to Diego Rodriguez's and Freedom Man Press, LLC's false, deceptive, misleading, or unconscionable acts or practices concerning plaintiffs that were made or committed in connection with the charitable solicitation. Instruction 27. Count 7. Violation of the Idaho Charitable Solicitation Act damages. Plaintiffs have established that defendants Diego Rodriguez and Freedom Man Press, LLC violated the Idaho Charitable Solicitation Act. Defendants Diego Rodriguez and Freedom Man Press, LLC are liable for any injuries caused by the violation or violations. Injury for purposes of the Idaho Charitable Solicitation Act includes loss, detriment, or harm, whether to person, property, reputation, or rights. Damages for any such injury may include any of the following: 1. Actual damages. 2. Restitution. 3. Disgorgement of all monies donated. And 4. Punitive damages. Instruction 28. Count 8, civil conspiracy. The elements of a civil conspiracy have been established in this case. Civil conspiracy is not a separate claim. Thus, while you have heard the term civil conspiracy in this case, you will not be asked to decide an amount of damages due to the existence of a civil conspiracy because it is not a separate claim. Instruction 29, punitive damages. If plaintiffs prove by clear and convincing evidence that the acts of the defendants which proximately caused injury to the plaintiffs were an extreme deviation from reasonable standards of conduct, and that these acts were malicious, fraudulent, oppressive, or outrageous, you may, in addition to any compensatory damages to which you find the plaintiffs entitled, award to each plaintiff an amount which will punish each defendant and deter the defendants and others from engaging in similar conduct in the future. Punitive damages are not a matter of right, but may be awarded in the jury's sound discretion, which is to be exercised without passion or prejudice. The law provides no mathematical formula by which such damages are to be calculated, other than any award for punitive damages must bear a reasonable relation to the actual harm done, to the cause thereof, to the conduct of the defendant, and to the primary objective of deterrence. Instruction 30. Punitive damages, consideration of wealth. You may consider evidence pertaining to defendant's wealth and financial conditions. This evidence was admitted for your consideration only with reference to the question of punitive damages, in light of all other evidence before you, if you determine that such an award should be made in this case. Instruction 31, cautionary instruction on damages. By giving you instructions on the subject of damages, I do not express any opinion as to whether the plaintiffs are entitled to damages. Instruction 32, compilations. Certain compilations of portions of redacted videos have been admitted into evidence. Summaries and compilations are only as good as the underlying material from which they are comprised. You should, therefore, give them only such weight as you think the underlying material deserves. Instruction 33, redactions. You saw and heard video recordings and saw various other exhibits during the course of this trial. You may note that parts of certain recordings and exhibits may have lapses or breaks because some material has been removed or redacted. Do not concern yourself with or speculate about any such redactions. Instruction 34, implicit bias. The law requires that your decision be made solely upon the evidence before you. Neither sympathy nor prejudice should influence you in your deliberations, nor should you decide the case based on an implicit bias. Everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes that we may not be aware of. Implicit biases can impact what we see and hear, how we remember what we see and hear, and how or why we make important decisions. Evaluate the evidence carefully and resist jumping to conclusions based on personal likes or dislikes, generalizations, prejudices, sympathies, stereotypes, or any other biases. The law demands that you return a verdict based solely on the evidence, your individual evaluation of that evidence, your reason and common sense, and these instructions. Your faithful performance of these duties is vital to the administration of justice. Instruction 35, evidence admitted for a limited purpose. In this case, certain evidence was admitted for a limited purpose. I called your attention to this when the evidence was admitted. I remind you that whenever evidence was admitted for a limited purpose, you must not consider such evidence for any purpose other than the limited purpose for which it was admitted. Instruction 36, communication with the court. If it becomes necessary during your deliberations to communicate with me, you may send a note signed by one or more of you to the bailiff. You should not try to communicate with me by any means other than such a note. During your deliberations, you are not to reveal to anyone how the jury stands on any of the questions before you, numerically or otherwise, unless requested to do so by me. Instruction 37, concluding remarks. Members of the jury, in order to return a verdict, it is necessary that at least 3/4 of the jury agree on each question. However, the same 9 or more jurors do not need to agree on each question. Your verdict must represent the considered judgment of each juror agreeing to it. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You are not partisans. You are judges, judges of the facts. Your sole interest is to ascertain the truth from the evidence in the case. Now, the verdict form, special verdict form, is part of the instructions as well, so I'm going to read that to you. In the District Court of the 4th Judicial District of the State of Idaho in and for the County of Ada, St. Luke's Health System Limited, St. Luke's Regional Medical Center Limited, Chris Roth, Natasha D. Erickson, M.D., Tracy W. Youngman, nurse practitioner, plaintiffs versus Ammon Bundy for governor, Diego Rodriguez, Freedom Man Press, LLC, Freedom Man PAC, People's Rights Network defendants. Special verdict form, case number CB 01226789. We, the jury, answer the special verdict questions as set forth below. To reach a verdict on a question, at least 9 of the 12 jury members must agree. Question 1, defamation. It has been established that defendants Ammon Bundy, the People's Rights Network, Ammon Bundy for governor, Diego Rodriguez, Freedom Man Press, LLC, and Freedom Man PAC each made defamatory statements about each of the plaintiffs, St. Luke's, Chris Roth, Natasha Erickson, and Tracy Youngman. Please indicate the amount of compensatory damages, if any, you find were proximately caused by each defendant as to each plaintiff. Subsection A, defendant Ammon Bundy caused compensatory damages in the amount of one little I to plaintiff St. Luke's, and then it says the number of jurors that agree, 2 little I, plaintiff Chris Roth, 3 little I to plaintiff Natasha Erickson, and 4 little I to plaintiff Tracy Youngman. So on all of these individual questions, I'm not going to read the number of jurors that agree, but it's on the form. B, defendant People's Right Network caused compensatory damages in the amount of little I to plaintiff St. Luke's, little I to plaintiff Chris Roth, 3 little I's to plaintiff Natasha Erickson, and 4 to plaintiff Tracy Youngman. C, defendant Ammon Bundy for governor caused compensatory damages in the amount of 1 little I to plaintiff St. Luke's, 2 little I to plaintiff Chris Roth, 3 little I to Natasha Erickson, and 4 little I to plaintiff Tracy Youngman. D, defendant Diego Rodriguez caused compensatory damages in the amount of 1 little I to plaintiff St. Luke's, 2 little I to plaintiff Chris Roth, 3 little I to plaintiff Natasha Erickson, and 4 little I to plaintiff Tracy Youngman. E, defendant Freedom Man Press caused compensatory damages in the amount of 1 little I to plaintiff St. Luke's, 2 little I to plaintiff Chris Roth, 3 little I's to plaintiff Natasha Erickson, and 4 little I to plaintiff Tracy Youngman. F, defendant Freedom Man PAC caused compensatory damages in the amount of 1 little I to plaintiff St. Luke's, 2 little I to plaintiff Chris Roth, 3 little I to plaintiff Natasha Erickson, and 4 little I to plaintiff Tracy Youngman. Question number 2. Invasion of privacy / false light. It has been established that the defendants Ammon Bundy, the People's Rights Network, Ammon Bundy for Governor, Diego Rodriguez, Freedom Man Press LLC, and Freedom Man PAC each placed Chris Roth, Natasha Erickson, and Tracy Youngman in a false light in the public eye by publicly disclosing some falsity or fiction concerning Chris Roth, Natasha Erickson, and Tracy Youngman. Please indicate the amount of compensatory damages, if any, you find were proximately caused by each defendant as to each plaintiff below. A. Defendant Ammon Bundy. Bundy caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I's plaintiff Natasha Erickson, 3 little I's plaintiff Tracy Youngman. B. Defendant People's Rights Network caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I to plaintiff Natasha Erickson, and 3 little I to plaintiff Tracy Youngman. C. Defendant Ammon Bundy for Governor caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I's to plaintiff Natasha Erickson, and 3 little I's to plaintiff Tracy Youngman. D. Defendant Diego Rodriguez caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I to plaintiff Natasha Erickson, 3 little I's to plaintiff Tracy Youngman. E. Defendant Freedom Man Press, LLC, caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I to plaintiff Natasha Erickson, 3 little I to plaintiff Tracy Youngman. F. Defendant Freedom Man PAC caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I's to plaintiff Natasha Erickson, 3 little I's to plaintiff Tracy Youngman. Question 3. Intentional infliction of emotional distress. It has been established that defendants Ammon Bundy, the People's Rights Network, Ammon Bundy for Governor, Diego Rodriguez, Freedom Man Press, LLC, and Freedom Man PAC each engaged in intentional infliction of emotional distress against Chris Roth, Natasha Erickson, and Tracy Youngman. Please indicate the amount of compensatory damages, if any, you find were proximately caused by each defendant as to each plaintiff below. Little a. Defendant Ammon Bundy caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I to plaintiff Natasha Erickson, 3 little I to plaintiff Tracy Youngman. B. Defendant People's Rights Network caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I's to plaintiff Natasha Erickson, 3 little I's to plaintiff Tracy Youngman. C. Defendant Ammon Bundy for Governor caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I's to plaintiff Natasha Erickson, 3 little I's to plaintiff Tracy Youngman. D. Defendant Diego Rodriguez caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I's to plaintiff Natasha Erickson, 3 little I's to plaintiff Tracy Youngman. E. Defendant Freedom Man Press, LLC, caused compensatory damages in the amount of 1 little I to plaintiff Chris Roth, 2 little I's to plaintiff Natasha Erickson, 3 little I's to plaintiff Tracy Youngman. F. Defendant Freedom Man PAC caused compensatory damages in the amount of 1 little I to Chris Roth, 2 little I's to Natasha Erickson, 3 little I's to plaintiff Tracy Youngman. Question 4. Trespass. Boise. It has been established that defendants Ammon Bundy and Diego Rodriguez trespassed on the property of St. Luke's, Boise. Please indicate the amount of compensatory damages, if any, you find were proximately caused by defendants Bundy and Rodriguez below. A, defendant Ammon Bundy caused compensatory damages in the amount of I to St. Luke's. B, defendant Rodriguez caused compensatory damages in the amount of I to St. Luke's. Question 5. Trespass, Meridian. It has been established that defendant Ammon Bundy trespassed on the property of St. Luke's Meridian. Please indicate the amount of compensatory damages, if any, you find were proximately caused by Mr. Bundy. Defendant Ammon Bundy caused compensatory damages in the amount of I to St. Luke's. Question 6. Idaho Charitable Solicitation Act, Part 1. It has been established that defendants Diego Rodriguez and Freedom Man Press, LLC, violated the Idaho Charitable Solicitation Act. Do you find that plaintiffs suffered injury or harm as a result of the violation? Little A, defendant Diego Rodriguez's violation caused injury or harm to little I St. Luke's, yes or no? Little I Chris Roth, yes or no? Little I Natasha Erickson, yes or no? And little 4 Tracy Youngman, yes or no? B, defendant Freedom Man Press, LLC's violation caused injury or harm to 1 little I St. Luke's, yes or no? 2 little I's Chris Roth, yes or no? 3 little I's Natasha Erickson, yes or no? 4 Tracy Youngman, yes or no? If you answered yes to question 6, please answer question 7 with respect to that defendant. As to any defendant to which you answered no, skip question 7. Question 7. Idaho Charitable Act, Part 2. Please state the amount wrongfully obtained by the defendant's violation of the Idaho Charitable Solicitation Act, if any. Little A, defendant Diego Rodriguez. B, defendant Freedom Man Press. And that should be Freedom Man Press, LLC. Question 8, punitive damages, Part 1. If you have awarded compensatory damages under questions 1 through 5 and or 7 above, please indicate the amount of punitive damages, if any, to be awarded to a plaintiff against each defendant. If you find a defendant's conduct as to a plaintiff was malicious, fraudulent, oppressive, or outrageous, you may award punitive damages. Little A, defendant Ammon Bundy. 1 little I, St. Luke's. 2 little I, Chris Roth. 3 little I's, Natasha Erickson. 4 little I's, Tracy Youngman. B, defendant People's Rights Network. 1 little I, St. Luke's. 2 little I, Chris Roth. 3 little I, Natasha Erickson. 4 little I, or 4, Tracy Youngman. C, defendant Ammon Bundy for governor. 1 little I, St. Luke's. 2 little I, Chris Roth. 3 little I, Natasha Erickson. And 4, Tracy Youngman. D, defendant Diego Rodriguez. 1 little I, St. Luke's. 2 little I, Chris Roth. 3 little I, Natasha Erickson. 4, Tracy Youngman. E, defendant Freedom Man Press, LLC. 1 little I, St. Luke's. 2 little I, Chris Roth. 3 little I, Natasha Erickson, and 4, Tracy Youngman. F, defendant, Freedom Man Pack, 1 little I, St. Luke's, 2 little I's, Chris Roth, 3 little I, Natasha Erickson, 4, Tracy Youngman. Question 9, punitive damages, part 2. Did the conduct underlying each claim for which you awarded compensatory damages independently support the amount of punitive damages? A, Ammon Bundy, yes or no? B, People's Rights Network, yes or no? C, Ammon Bundy for governor, yes or no? D, Diego Rodriguez, yes or no? E, Freedom Man Press, LLC, yes or no? F, Freedom Man PAC, yes or no? If you answered yes as to all defendants in question 9, please skip question 10. If you answered no as to any defendant in question 9, please proceed to question 10. Question 10. Punitive damages, part 3. As to any defendant for which you answered no for question 9, please write down the count or counts in the corresponding plaintiff or plaintiffs for which the conduct does not support your punitive damages award. And then there's A, Ammon Bundy, counts or plaintiffs. B, People's Rights Network, counts or plaintiffs. Ammon Bundy for governor, counts or plaintiffs. D, Diego Rodriguez, counts or plaintiffs. E, Freedom Man Press, counts or plaintiffs. F, Freedom Man PAC, counts or plaintiffs. Once you have completed your answers to each of the questions, have your foreperson sign the verdict form and notify the bailiff you have reached a verdict, dated and signed by the foreperson. Ms. Jensen, can you approach?
Are we good to go? I know I'm being really picky, but is there a comma between Freedom Man Press, comma, LLC, or not? Because we've got it sometimes and sometimes not. You think there is? I don't think it's an issue. Do you think it's an issue? Okay, we'll just leave it as is then. Thank you.
Can you just approach on what you request? Do you just need a hard copy of the instructions? You can use those. So all right, now we're going to proceed, when my clerk's ready. You're good to go? With closing argument. Mr. Stedham?
Thank you, Your Honor. Your Honor, ladies and gentlemen of the jury, on July 10th, the first thing I think I said was that Mr. Bundy and Mr. Rodriguez were cowards for not being here. I think after the days that have occurred, nothing has been truer than that statement. Because in contrast to what has occurred with these gentlemen hiding, the plaintiffs over here have been brave enough to come forward and use this forum. And they've been brave and patient, because the lies and the false conspiracies that were spun by Mr. Bundy, Mr. Rodriguez, well over a year or so ago, have not been able to be directly refuted by my clients because of HIPAA laws. Now, as you know from having heard the testimony, that first big lie related to the health of that infant. So Dr. Erickson, Tracy Youngman, St. Luke's, and the others have abided by their duty. They haven't said anything. They haven't disclosed the reality of how false that first lie is until they had an opportunity to present evidence here during this last 2 weeks. And you've seen the efforts that have been made to continue to conceal and protect that infant's identity. But you've also seen how tremendously and egregiously false that statement has been that they built this entire conspiracy on, that a perfectly healthy baby was taken wrongly from its parents. What you heard testimony on these last 2 weeks from Tracy and Dr. Erickson and other doctors is the reality is that when the professionals who took this stand under oath testified, that infant was at risk of death, severely malnourished, dehydrated, and although the doctors didn't use that term, the reality was that infant was starving and potentially starving to death. And the reason I bring us back to that as I lead into this is to remind all of us about how heinous the very beginning of these false statements and conspiracy is. These two gentlemen built all of this on a lie about an infant who was protected from dying. So when we look at what we've actually heard, for example, regarding Tracy Youngman. Tracy Youngman was accused for the last year and a half by these people of being a pedophile, of being involved in a conspiracy to hurt children, when the reality is she works helping children who actually are suffering sexual abuse, neglect, physical abuse. The reality is she went out of her way to take care of that infant, even when she was being attacked and at risk. Recall the testimony of Ms. Youngman, that in the days after, even after the lockdown, she was continuing to take time after work with security in dangerous situations to go provide care to that infant, knowing, as she did, what was already being said by Mr. Rodriguez and Mr. Bundy. In particular, remember what you heard about a particular instance when she went to Health and Welfare office at Westgate. It was after hours. The parents of the infant needed help because the feeding tube that was necessary was out. She went. She replaced it. Testimony from all the doctors that you heard, she replaced it exactly how she could. And she replaced it in a manner that could not have resulted in any harm to that infant. What happened? Days after that event, Mr. Diego Rodriguez was already posting on Freedom Man, in the midst of all this conspiracy, that she had committed malpractice, harmed the infant. Then, once he got to know her name, he continued to build on that, and build on it, and build on it. When the reality is, all Ms. Youngman did was take care of an infant. They made up lies about her having somehow wrongly recommended that a perfectly healthy baby be taken in by law enforcement. Well, you heard law enforcement testify that Ms. Youngman did what she always does when she works at CARES, is she provides a medical consult so that the law enforcement and Department of Health and Welfare can make those decisions on protective care. And you learned in this instance that the advice she gave and the consult she gave was incredibly helpful and helped result in what was potentially a life-saving event, taking that infant into protective care. Dr. Natasha Erickson, she took care of the infant even before the protective care. When the parents took that infant to emergency department at St. Luke's, what did she do? She immediately took the infant into care. She was a hospitalist there working that night. She developed a feeding program with the assistance of others there. She worked around, as you'll recall the testimony, the evasive answers from the parents regarding the infant's medical history, provided care, got him set up with a feeding plan, even got a consult from somebody to help the parents with potential medical issues relating to the bills. When the infant was taken into protective care, 4 days after he left the care of Dr. Erickson, so we're in the March 12th time frame, she was honest when she was on the stand, and she was angry because that infant that she had taken care of on March 1st to the March 4th had gotten worse because the feeding plan that she had developed was being ignored, not followed by the parents. The seriousness of this infant's condition was being disregarded to the extent that that infant was at risk. But what did she do? She got the call on March 12th. She already knew that Mr. Bundy had started to get his involvement, but she marched down to St. Luke's downtown on her day off. She took care of the infant. Chris Roth, accused of wanted, remember the wanted poster, accessory to child abduction? Then later on, as the narrative regarding him developed, he was mismanaging funds, he was stealing. Well, what's the reality here? Mr. Roth's role is to oversee an entire operation. He's not involved in those decisions. There's no evidence that he's somehow personally taking money. All of that false. Then we talk about the allegations against St. Luke's, the institution, allegations of being involved in child trafficking, allegations of making money off these situations where these infants are taken in protective care, allegations that they were abusing the infant while it was in their care. All lies. All lies that my clients have waited over a year and a half to tell a jury. They wanted these two men to be here. They wanted them to be here. The other thing, in addition to the cowardice of these men not showing up, is the hypocrisy. You've seen clips of both these men talking about accountability. Where are they now that it is their time to be held accountable? They're hiding. That's the backdrop for this litigation. Hypocrisy, cowardice, and lies that these gentlemen are trying to hide from, even though this institution and your job exists so that the truth can be found out. So These three people, in addition to what I said, showed bravery because they knew what was going to happen when they proceeded with their legal rights. They knew that they were going to be attacked by Mr. Bundy and Mr. Rodriguez after the lawsuit was filed. And you've seen evidence that that's exactly what happened. But these three people in St. Luke's, they marched forward until today. That is the opposite of what these two gentlemen did. And I'd like to talk to you today as we move forward about why we put on certain evidence. Because our situation here is different than the typical case. As you understand and you've been told, there's a 47-page complaint that you listen to first off here. The facts in here are deemed established, they're deemed true. So this will be the bedrock that you'll rely on when you go back for deliberations. So why did we put on the evidence we did? We put it on for largely a couple of reasons. First, the obvious one is damages. We need to establish the elements of damage and connect those to those allegations that are deemed as true. But in addition to that, as I just talked about in establishing the truth and the reality regarding that poor infant, is that we need and wanted to present the evidence that shows the maliciousness, the fraudulent nature, and the outrageousness of the conduct of PRN, Ammon Bundy, Diego Rodriguez, Ammon Bundy for governor, and Freedom Man. So that is why we put together the evidence we did. Now, we didn't touch on everything that's in the complaint, but we tried to touch on things that we think will be helpful to you as you go into deliberation. And what we wanted to show in the evidence we produced, or presented, I should say, was first, who is Ammon Bundy and PRN? Like I said, they're not here. So what we did, and so we couldn't call them to the stand. So we brought in Mr. Devin Burkhart, who works for an organization, and I won't repeat everything. You were attentive, and he was on the stand for quite a long while. But we brought him in so you could understand what PRN is. Because what PRN is, in reality, it's not that face sheet of the computer page, the web page that you've seen, with friendly families holding hands. PRN is Mr. Bundy's, as Mr. Burkhart called it, Ammon's Army. PRN is the organization that also is in that video you saw of Mr. Bundy a couple of times, where he's at the whiteboard, kind of mapping out potential military-style maneuvers. PRN is the entity that used all of its might to help defame St. Luke's and the individuals over the last year and a half. We wanted to do what we could to provide you a picture of who PRN is and also who Ammon Bundy is and Mr. Rodriguez is. We also called individuals from the Department of Health and Welfare and law enforcement in. And that's because that initial lie that I talked about, as you've seen, was purposely manipulated and grown into a vast conspiracy. A central component of that conspiracy is this false allegation of child trafficking and kidnapping involving Department of Health and Welfare, the prosecutor's office, and law enforcement. So we wanted to bring in those individuals so they'd have a chance to, in a similar way to what my clients waited for, deny it. Deny the lies that they've had to deal with for the last year and a half, and then also tell the truth about the reality of their organizations. And they also told and shared with you something that I believe is going to be very relevant to your deliberations. How they were also doxxed, how they were targeted. Now, they're not plaintiffs in this case, but the testimony that they provided when you go through the jury instructions and look at the other aspects of this case, we believe will be relevant and helpful in you making some of those decisions. And then in addition to that, as you know, we put on a number of St. Luke's employees. And for lack of a better dividing line, I kind of break them into two categories. We had the St. Luke's employees who testified and explained about the operational difficulties they had to deal with when St. Luke's was under attack by Mr. Bundy and Mr. Rodriguez and PRN. We had them talk about the lockdown, the phone calls, those aspects of the attack that St. Luke's was forced to deal with. We also called some witnesses like Beth Toll, who you might recall, of communications. She testified about that too, the challenges that St. Luke's facing. But she also testified about what she saw. I would ask you to recall what Ms. Toll discussed when she was watching real time what was happening. Remember, she was on incident command from March 12th forward. And she has the expertise to see, as she was watching the different information coming in, that St. Luke's was under a coordinated, highly skilled, I think she called it corporate attack. That Mr. Bundy and Mr. Rodriguez, through their resources, were using social media and using other platforms to start to build this machine that they continue to feed to this day and target it against St. Luke's. We also had some St. Luke's folks come testify about subjects and issues that are going to be directly relevant to what you're going to go back and decide, and that's damages. We had St. Luke's folks talk about the hard, immediate economic impacts. Ms. Fowler testified about the missed appointments, cancellations of appointments, and the impact there, and then the increased costs going forward. And you heard Mr. Abendondolo and others talk about those security costs that are going to be necessary going forward. And then in addition to that, we had some experts that we hope and believe provided testimony to you that's also going to be very helpful in your deliberations. And one of those that I would ask you to consider as you go back into deliberation is her testimony, and that's Jess Flynn. Now, Ms. Flynn went through very thoroughly, and I hope very helpfully, the business side of this, because a central aspect of what we think is occurring here relates to what we would call this business model. Because Mr. Bundy and his organization is a lot of things. We've talked about the intimidating and threatening aspects of their malicious style activities, and Mr. Burkhart talked about the various disruptions they're involved in. But what Ms. Flynn, we hope, exposed for you is this business model. And you heard about it when you first listened to our complaint, because that is very much at the core of the case that St. Luke's and the other individuals are presenting. And that is, at the core of this, in addition to some of the intimidation and other things like that that most people traditionally associate with Mr. Bundy, there is this machine that they've built. And it's a machine built for profit and publicity. And we've called them conflict entrepreneurs, and we've hopefully provided you evidence and testimony that helps you understand that machine. Because this business model of theirs is not one that, which would be egregious enough, has collateral damage, that it's hurtful in a way when it seeks profit. This business model of disinformation, as Ms. Flynn talked about and others did, the object of the business is to target individuals, put targets on their backs, hurt them, and then use them as fodder to build up their followers, to build up this base. They don't hurt people as collateral damage. The object and the method by which they make their money is to create false conspiracies, to target people, to direct animus and engage people using those false conspiracies. And as Ms. Flynn testified, it is a widespread and, as best we can tell, wildly potentially profitable business. We talked about the model they follow, too, and Mr. Fomby touched on this. So you heard from Ms. Flynn about the business aspect, and then you heard from Mr. Fomby about how there's this overlay on that business, which is very much in line with what he called the extremist playbook, and that you find a triggering event. In our case, it was a protective care of this infant who very much needed help. The initial falsehood, healthy baby taken. The conspiracy, kidnapping and trafficking. And then you spread it through extremist media, as you've seen held up numerous times. And as was done here, as Mr. Fomby testified, this overlay is not just PRNs, it's Antifa's, it's a propaganda tool. It is just simply an extremist tool that can be used wrongly by really anyone who wants to. And the fingerprints of that type of a playbook, we believe, were all over everything. And just to give you a sense of the type of damage that was done, just looking at this one instance, and we're talking about individuals targeted, you've seen this before. This is what Mr. Bundy and Mr. Rodriguez did. They went after these individuals, and they went especially hard after these plaintiffs. And the objective was the grift, because they monetized things in a couple of different ways. You saw the donate button everywhere. There's another example there. The calls to action, as Ms. Flynn and others have talked about, right there next to the falsehoods about Ms. Youngman, right there next to the falsehoods and lies about Ms. Erickson. And then they also drive folks here through these conspiracies, which is to membership. And this is another aspect, a second aspect of their marketing technique, or disinformation technique, I should say, is they take that big lie, they turn it into a bigger lie, a conspiracy, and then they create a third lie, in effect, that becomes a testimonial. And so that was another piece of evidence we wanted to provide you when we brought in these other organizations, because you heard this lie that PRN is effective, this lie that they use to get more members, is completely false. DHW attacked, did exactly what they were supposed to do. Mr. Bringhurst, the prosecutor, testified. He was being doxxed. His kids' faces were being spread out there by these people. He did what he was supposed to do. The detectives, the officer who was called a groper, the detectives who had people coming to their house, they did what they were supposed to do. And most importantly to this case, everyone at St. Luke's who testified, despite the lockdown, despite anything else, they continued to do what they were supposed to do, protect the infant. They didn't bow, they didn't break. And that's why I think this lie is among the most offensive. That they pretend at PRN, Mr. Bundy and Mr. Rodriguez, you heard them tout it several times, that this tactic of intimidation somehow was effective. And they spread this lie as if that infant was saved through their intimidation. The infant was saved because he was placed in protective care owing to people like Tracy Youngman. You've also seen how they then try to drive that membership growth through slick ads. Slick ads, highly produced, I believe you'll recall this one, in which they make St. Luke's somehow a villain and part of a testimonial. You might remember this one because Mr. Bundy talks about himself somehow rescuing this infant, completely false, among video of World War II fighting men storming the beach at Normandy. They're building this narrative, they're using this falsehood, and they're monetizing it through growing memberships. And again, we don't have the information we should have if these men did what they, well, If these men had shown up and participated, we'd get financial information in litigation like this. I think it's pretty clear that one of the reasons that they're not here is they don't want us to get that, or I would say the evidence certainly indicates that. Because what we do know and what we can see is a pretty straightforward model where they drive members in, they get them to donate, one of the ways that they get folks to donate, and then we can see that there's a Wyoming corporation that receives some donations, Ammon Bundy, and that there's a for-profit church that Mr. Rodriguez owns that receives some of the money. And then, as Mr. Burkhart testified, there's evidence of significant amounts of cryptocurrency that are also being pulled into PRN. The other way that they monetized this was something that Ms. Flynn also testified to. And again, we asked her to look at this as a business, and she did. And the numbers are huge. As you know, she went through that analysis, and she talked about the interlinking, the manipulation of different words, different calls to action, the sophisticated techniques that PRN, Rodriguez, and Mr. Bundy are involved in. And she gave us a metric. We asked her what the metric is in the industry that can be used to try and get your hands around the value of what they were doing. And one of those metrics, the metrics of what it would cost if you had to pay for this kind of exposure, is about $23 million. So it's fair, I would suggest, and we'll talk about how we believe that might fit into your deliberations, that you keep in mind that if you look at what is being done, as we believe you properly should, as a business, these folks used their targeting and attacks on St. Luke's to generate about $23 million worth of advertising and exposure for themselves that they would use to get additional members, raise their profile within the extremist community, build their power, and build their strength. And we would suggest that this evidence be considered in the jury, when appropriate, under one of the questions you're going to be asked to answer, and support a decision that this business model should not be accepted as it was targeting against these three individuals, and that this business model and the men who drove it should be held accountable. And as you know, moving on to an issue we face given, I would say, almost the uniqueness of this case, there's a number of legal concepts and principles that you folks are working with. One, as you well know, is default. Another, which the judge touched on and which you'll see when you look at the jury instructions, are adverse inferences. And it's fair to say that those are efforts by the law that are meant to protect plaintiffs like mine and mitigate the adverse consequences of when some people try to opt out of the system strategically, when they try to opt out of the litigation to get advantage. For example, to the extent Mr. Bundy and Rodriguez opt out so that we can't get their financial information, the reaction of the law is, as you've seen, one step would be the default, where you take the allegations as established, and the other will be what you see reflected in those jury instructions, what you heard from the judge, that you're going to be asked to make adverse inferences. All efforts to try and mitigate the unfair disadvantage that strategic default, strategic opting out of litigation can cause. And this is just an example of what you'll see in those adverse inferences. And as you'll see, and as you'll recall from the judge reading, some of those inferences are intended to fill in the blanks in a way, in a favorable way for my clients, for the information that we just couldn't get. Those email communications, those financial documents, those types of things that we don't get when a strategic opt-out occurs. And I would just highlight those inferences for you and ask that you give them, which I'm sure you will do, fair consideration as you go back and deliberate. Then if I could talk about harm, the damages evidence that we put on. We put on evidence, we believe, of what I would call more immediate harm. You heard testimony from Ms. Fowler and then Mr. Reinstein and others about, again, those canceled appointments, the immediate connection of lost dollars, or relatively immediate connection of lost dollars to those events and those attacks on the hospital. And then you heard testimony, because it's significant in this case, about ongoing threats. The ongoing threats that exist because these lies continue on the internet, the ongoing threats that exist because Mr. Bundy and Mr. Rodriguez are unabated in their efforts to continue to pump out content here, and the ongoing threats that relate to radicalization. You heard Mr. Fomby touch on that, and you heard Mr. Burkhart touch on that. And that's an adverse effect that is underway, and it's a variable. The radicalization can result in things like what we've heard, these phone disturbances, people stepping out against St. Luke's, but it also creates a very real possibility, as Mr. Fomby testified, that there's going to be somebody who's going to go after St. Luke's, and more frighteningly, to go after Ms. Youngman, Mr. Roth, or Ms. Erickson. And that's something that exists, and it's not going to go away, and it's something that is created as a result of the wrongful actions taken by the defendants. You heard testimony about the PRN disruptions from Mr. Burkhart. Those were also referenced by Mr. Abendondolo and Mr. Fomby. The significance, we believe, of that evidence would be, again, a factor in the ongoing threat and the risks that are posed by PRN going in the future. So the way that then comes together, as far as it relates to compensatory damages, are you have the job. I'm not going to pretend like it's an easy one, but you have to think about how much needs to be compensated to deal with damages that are likely to occur in the future. Just given the nature of time and reality, you have the challenging position of having to listen to the evidence and think about compensating for damages that have not and challenges that have not necessarily occurred, but are reasonably likely to occur in the future. And so when you think of these damages that you're going to be considering, these causes of action, I should say, related to them, there's going to be a component for you to consider for the likelihood of future security costs for St. Luke's. And you heard Mr. Abendondolo and Mr. Fomby talk about that. And you're going to have to think about how that then plays out in a couple of different ways. So I'm not going to pretend like these are not big numbers, but they're the numbers that the experts have come up with in a number of categories. So we've talked about the canceled appointments. That perhaps you'll see as straightforward. We would hope that you would see that as straightforward. Ms. Fowler addressed that. Mr. Reinstein also addressed how they calculated that. And then you've got the one-time security costs that would be in that tranche that I talked about that are real time. But then you have, a category, for example, there, 5 years of PR and marketing campaign that Ms. Flynn talked about. And you have the challenge of deciding and thinking about what the testimony was, what the threat is, what the need for that will be in the future. Similarly, in the realm of the security costs. The total compensation that you see at the end of that is about $37 million. Now, the experts that have testified under oath and the members of St. Luke's have testified under the oath believe that that is a reasonable number that reflects the damages that have been caused by the defendants in this case to the institution. Part of your job will then to decide whether that range is right or whether a different range is right. And that's why, for example, when we asked Ms. Flynn to come up with her numbers, and we asked Mr. Reinstein and Mr. Avendondolo and others to come up with security costs, we asked them to put them in segmented groups, because we understand that that's your job to decide, if you decide to award compensatory damages, how you need to factor in the threats going forward to arrive at what you feel is a fair and reasonable number. So if, for example, you decide that the timing and the risk is not as great as that previous model reflected, you have the tools to decide how to move that back more in line with what you believe the evidence shows. And you do have the evidence, we believe, to move it back to what we at least would believe, based on the evidence presented, would be the floor. A number that doesn't reflect looking very far in the future at all, but that does reflect the very real damages that we incurred. And just by way of example, the type of work that you're going to have to do in the room, if you were to reach what we consider as the floor, we're still looking at what is a real number, $16 million. But to pretend that the number is something less than that would be to ignore what these gentlemen and their institution really did. And we would ask, and you go back into that room, and you also consider the inference that exists regarding financial information, that you just give, as I'm sure you will do, fair consideration to the testimony you heard about the length and the duration of these future risks. You're also going to face the challenge of deciding, how do you assess damages if you decide to award them to these individuals? Each different, each testimony a little bit different, but also around kind of a core. They were all victimized and targeted by the defendants in this case. We'd ask you to consider, of course, the testimony from Tracy Youngman. And I should say at the outset, you're going to be considering emotional distress damages for some very tough people. I mean, it's not an easy job to be dealing with abuse victims. It's not an easy job, if you're Dr. Erickson, to be dealing with hospitalized children, some who die. And then Mr. Roth is a CEO of a very large corporation. These are not hothouse orchids. I would just ask you to factor in the reality of who they are with what's an appropriate measure of damages, because they should not be punished by the fact that they're tough people. And when you consider Ms. Youngman, just consider some of the statements she made in the testimony, which I'm sure you will do. Also consider what Dr. Camille Lacroix said when she was brought in, and which can be no treat for Dr. Erickson or Tracy Youngman. They provided time and consulted with Dr. Lacroix, and they sat in here while the two men who caused all this and their organization were hiding. And they got to hear this doctor very frankly and matter-of-factly talk about the fact, excuse me, that she believes beyond a, whatever the standard is, medically reasonable level of doubt, that they have PTSD. Similar to Tracy Youngman, you heard from Natasha Erickson, falsely identified as a child trafficker. She provided testimony on topics from those discussions she had to have with her children. She was open about the effects she's felt when she was dealing with patients, how it's modified her behavior, her interactions. You might recall what I thought was a particularly compelling piece of testimony when she talked about some period of months from when this all happened, that she mentioned the infant's name when she was dealing with an infant with a similar last name, and it just shook her because she realized that all this anxiety she felt was still tied to that. And I think as she testified, that prompted her to seek additional care. And she, likewise, has been diagnosed as having PTSD and acute stress disorder by Dr. Lacroix. And Mr. Roth, he has not been diagnosed with either of those circumstances, but he was doxxed, and you heard his testimony, which was the security concerns he deals with, the concerns he has with his family. You heard the testimony about him getting a gun that he'd never had before, putting it under his bed. Testimony of his brother-in-law coming in and teaching his kids what a safe room is. That's the kind of evidence that you'll be working, I'm sure, to deliberate on to reach your conclusion as to what's appropriate for Mr. Roth. And then the final category, if you decide to award punitive damages, will be consider the factors that go into that, the maliciousness, the fraudulent, and oppressive and outrageous nature. And again, because we're in an odd circumstance, when you look at the jury instructions and the jury verdict form, some of the steps that typically are involved in getting to the punitive damages stage have already occurred, but you will have a very significant job of considering what's been presented to you and considering whether that evidence is of a maliciousness, a fraudulentness nature, that it needs to be punished. Because punitive damages are different than the compensatory damages we've talked about to make people whole. They're to punish, and they're to deter. And you've heard, we believe, a lot of testimony about the intentional nature and the malicious nature of these lies. By way of example, remember what Mr. Rodriguez did to Dr. Thomas, the emergency room doctor, with that ad he had, or excuse me, that program he had, Medically Stable. Well, we saw that he had just edited the body cam footage to make it misleading, that he had attributed medical records to her that weren't hers. And if you just think about that, and that's just one instance of many, he had those medical records, he had that body cam footage. There is no way that that cannot be intentional when you're cherry-picking records to provide a misleading perception and you're editing video out of context. And Dr. Thomas, she's not a plaintiff in this case. She's not a plaintiff in this case, but she was very brave and she came in here and talked about it. And she talked about the fact that she's moving to New Zealand. Again, not another shrinking violet. This woman is in charge of 9,000, I believe she said, medical providers. She volunteered in Haiti. And she testified, she's one of those people that I mentioned earlier who testified about how sick that infant really was. But she reflects another example of a St. Luke's employee who did exactly what they were supposed to do, although they were being harassed. And she also reflects what you can and properly should consider about whether this type of activity needs to be deterred, whether it needs to be punished. And you heard, again, if I move to the systematic level and go back to what you heard from Ms. Flynn and Ms. Toll, you've had folks hopefully provide you with evidence that's helpful to you to see the intentionality doesn't just exist when Mr. Rodriguez is wherever he is editing those videos, but it exists when coordination is occurring real time back in that March time period to try and coordinate across platforms to maximize the damage of what, again, Ms. Toll referred to as a corporate attack. And it also reflects the intentionality of something like Ammon Bundy putting St. Luke's in that highly polished video for PRN, Ammon Bundy using this to further his gubernatorial campaign, I refer you back to some comments and information Ms. Flynn provided about the timing and use of his campaign to further this false narrative. You saw a highly produced commercial from Mr. Bundy using this false narrative in his political ad to obtain money and votes and polish up his public perception. He knew that was false. There is no way that man didn't know what he was doing is false. And those are the factors and the evidence that we believe are things that have been presented and hopefully will be helpful to you when you're making these decisions about maliciousness and punishing. The other aspect of what you have to do relates to deterrence. And at the risk that I just want to go back to March 15th here. Because you've been provided a lot of evidence, we believe, about what needs to be deterred. But if you go back to March 15th, that should never happen again. There were false statements, false incitements of a mob that approached several hundred, armed. You heard testimony from Mr. Abendondolo, Mr. Masaros about what was going on. You heard Mr. Fomby just testify today about the reality of that situation. There were 30 policemen who were brought in and a full complement of St. Luke's security. They were far from sufficient to deal with that. And you heard Mr. Fomby talk about the scenarios that were very real and very potential. Groups getting in, shootouts in the hospital, all of that. And you heard, and I apologize for that, you heard those calls that were coming in. That should never happen again. Shutting down phone lines at a hospital so that you can make money off a false narrative. That is, I would suggest, profoundly malicious. And that is activity that not only needs to be punished, but to be deterred. I won't paraphrase Dr. Souza or the others who testified, but hospitals do have a sacred place. To have somebody just lie and target a hospital based on this false narrative that an infant is sick or being abused. Think about all the people in that hospital who are put at risk. Think about all the people in that hospital that are being put at risk for this horrible business model that PRN and Mr. Bundy are continuing to pursue. That, I would suggest, is something you need to consider when you're considering deterrence. Because this can't be acceptable, I would suggest. It needs to be stopped. And you heard Mr. Fomby testify today about the individual and the group that if you decide to look at punitive damages, you're going to be considering how to deter. He hasn't been deterred to date. You saw the video about how he was dealing with that one aspect of the legal process. He's not here. He's continuing to attack the clients. So the question is, and Mr. Fomby firmly believes it, and my clients firmly hope it, that you will look at this as something that needs to be deterred, and you will deter him in a way that he hasn't been deterred yet, and that we believe will be effective. And that's in the pocketbook. This massive grift, this ugly machine he's built to make money and to radicalize people, that is a business. And we would suggest, if you believe it's appropriate, you think about the man and you think about the horrible nature of what he's building, and you figure out a way to end it. And I would just leave with the phrase that Mr. Bundy used for his own organization. He referred to PRN as being a den of rattlesnakes. That may be one of the true things he has said. That needs to be deterred. That needs to be stopped. Thank you.
Thank you. All right, ladies and gentlemen, this is the time where we draw the alternates. And the individuals that are drawn as the alternates, I want you to know that you have the sincere thanks of the court as well as the parties in this lawsuit for the attention that you've paid to this case. We started out with 3 alternates and something came up. One juror became sick, so I think you can understand why we carry alternates. And the longer the trial, the more alternates we carry so we don't have to start over. So regardless of whoever these 2 are that I randomly draw, I want you to know that your presence and your attention to this case has been greatly appreciated. Secondly, I want to mention that you need to heed the admonitions of the court given. It could result that you may have to be called back and deliberations started again if one of the persons who remains to deliberate has something come up or becomes ill or something like that. So it's very important for the alternates not to discuss the case, not to do any research about the case, do not read about the case, do not allow yourself to be approached about the case. The alternates' notes will be saved in an envelope for each alternate, but they will not be used by the deliberating jurors. If you come back to deliberate, your notes will be made available to you. Once the jury has reached a verdict, you will be notified, and at that time you would be free to discuss the case in any manner in which you desire. But at this time, I'm going to draw the 2 alternates. It's a very sophisticated system of putting this paper out here. All right, so juror number in the 7th seat, original laminated number 32. All right, you are one of our alternates. And the other alternate is juror in seat number 9. And you were laminated number 37? All right. So you 2 are our alternates. And I know this sometimes can be disappointing, but I hope you realize how important your roles were. So at this time, I'm going to have the clerk swear the bailiff. Maybe both of them.
Do you solemnly swear or affirm that you'll keep this jury together in some quiet and convenient place, that you will not suffer any communication to be made to them or make any communication to them yourself on any subject connected with the trial of the case, except to ask if they have agreed upon a verdict, and upon their agreement upon a verdict, you will return to open court or the order of the court. Thank you.
All right, so at this time, ladies and gentlemen, bailiffs will take you back to the jury room. The 2 alternates will be excused. The exhibits that have been admitted will be brought to you, copies of the jury instructions, and a verdict form. If you feel like it might be helpful to have additional copies of the verdict form just for work purposes, you can send out a note and we could have that done if you find it would be helpful. So I've previously admonished you every time not to deliberate when you leave the courtroom. I'm now telling you that the case has been submitted and you may begin your deliberations. Your cell phones will be taken from you, as well as any other electronic device while you deliberate. It's up to you how long you wish to deliberate tonight, and you can give me further advice if you wish to deliberate past 5 o'clock or not. I'm really going to leave that up to you. All right? It's fine for you to come back on Monday and deliberate. Whatever you feel you would, however you feel you would like to proceed. Okay? Thank you very much.
All right.
be seated. Counsel, my practice is that if I get a question, I will call counsel back to the courtroom, and I will give you the jurors' questions. I will tell you my proposed answer, and you can give me any feedback you wish to give me, and then the court will give an answer to the questions. Additionally, before the jurors leave for the day, I will call them back into open court, and I will admonish them again not to do any research if they decide to continue, stop deliberations, and come back Monday. So it's important that counsel, as well as the parties, be available to come back to the courtroom should I need to admonish them. As for any questions, I'll deal with the questions just with counsel. Do you have any other questions for the court?
No questions, Your Honor.
All right. Please give my clerk the best contact information for you and the other counsel.
We will, Your Honor.
Thank you very much.
All right.
Please be seated. All right. Ladies and gentlemen of the jury, I've been advised that you wish to break for the evening, which also means you're breaking until Monday. You all understand that. So this is going to be a little bit longer recess, again, over the weekend. It's very important that you make sure you do no research about the case, do not read any articles about the case, do not listen to any radio reports about the case, and do not allow yourself to be approached about the case. So make sure when you come back Monday, you can answer that nothing's happened to affect your qualifications. I'd like you back to start with jury deliberations again at 8:30. Okay, same time we've been starting trial. Is that a problem for anyone? All right. Monday at 8:30. Stay healthy. We'll see you then. Mr. Bailiff, is there any issue we need to discuss with counsel?
No, Your Honor.
No, with the exhibits. Okay.
Apparently, they're making attempts with it, but all I gotta ask Rick is there a passcode on the flash drive?
Is there a passcode on the flash drives?
Because they haven't figured it out yet. That's why I don't have anything in answer, but.
Okay. So I don't know if you could just check with your support staff. It may be operator error by the jurors, in which case we'll provide them with a different wiped laptop to use Monday morning. But if you could just confirm whether there's any type of passcode, that would be helpful. And you can just email my staff attorney. All right.
They made an attempt and it wasn't successful, so they got back to me with possibly a passcode on the flash drive.
We'll figure it out on Monday, but if you could just check.
We will.
Thank you. Have a nice evening.
Thank you, Your Honor.